Yes.
For reasons mentioned in the orders, this interlocutory application is allowed with following direction.
दोनों साइड में चल रहा है, क्या कर रही हो तुम? काट नहीं सकते एकदम। हैं?
Ramesh, BC of
भूलने का काम नहीं क्यों हुई वो इमान दूर है सेकेंड्स
জন্য করলে তো আরো দিগদার হবো
জয়েন তো করি থাকা কিন্তু ভয়েস টু
deny Putul. Right, to meet her child, minor son, Master Kairav Datta Medi, who is presently in the interim custody of his father. If the decision-making process of the custody application pending before the family court takes a longer time, the terms and conditions of such visitation right of the applicant shall be as decided by learned Principal Judge Family Court number 3 from time to time. Even while finally deciding the custody application pending before it, the family court shall have to consider and have a stipulation regarding visitation right of the parent who would not be ultimately getting the custody of the child. During the forthcoming school winter vacation of the child from 26th December 2025 till 10th of January 2026, the applicant shall.
Your Lordship, I may be allowed to collect that matrimonial petition.
Yes, you may take it back.
Item 16 to 18.
So all these are connected matters, my lord. Otherwise, my lord, TCR is available, my lord. So, my lord, allow me some time, my lord, itself to go through the TCR. In earlier occasion, my lord, in one of the matter, my lord, that is CD was not available. That is on, my lord.
Then we'll take it at 2. At 2.
At 2, my lord.
We'll take, okay, at 2.
My lord.
Highly available. For this one, item 1.
If revision is director against an order, whereby, my lord, I have been gone to take. My lord, the facts of the case is this, my lord, an eviction suit was filed. Ultimately, we approached the Honorable Court. If your lordship comes to page 40, my lord, this Honorable Court disposed of the same.
What is this?
This is the order by which, my lord, the revision was disposed of. As agreed by learned counsel for parties and having regard to the facts of present case, this revision petition is disposed of on the following terms. As soon as the plaintiff landlord is ready to commence the work of construction, 30 days advance notice shall be given to the revision petitioner. Tenants.
You are the landlord,
Tenant.
tenant.
And thereafter, the revision petitioner tenant shall vacate the suit premises at least 15 days ahead of the date of commencement of the construction work, which date shall be indicated by the landlord in the notice to issue. The landlord shall complete the construction expeditiously as possible, and no sooner the same is complete, shall offer equivalent area as held by the tenants as on the date in the reconstructed premises which naturally will be subject to payment of rent by the tenant. If them say this was not. Now, but what happened, there is a review petition. Now, if your losses comes to page,
Lordship, I also read the second page of the order. That's relevant. my lord. Page 46 of your lordship's
so
page.
I am coming to that, I'm not,
That's very relevant.
page 45 I am reading. My lord, the revision petition was disposed of under following order. Now, next page, my lord, that order has been executed. With the aforesaid, this revision is
Which
sent-
page, which page?
Page 45, my lord, the earlier order has been quoted.
No.
Here, my lord, your lordship got it, my lord,
No, in 2004, the revision petition was disposed of.
disposed of.
Then why it again came up?
My lord, there is a review matter, my lord.
Or review, okay, okay.
So in the review, my lord, this is the final order passed. The same was quoted. Then, my lord, next page. With the aforesaid order, revision petition is closed in terms of the conditions agreed between the parties, the court insurance for landlord would be entitled to proceed the construction if needless to say that current rent, area rent, if any, will also be paid by the landlord tenant. Now, my lord, there was a we approach the Supreme Court also, my lord, here. The losses will come to my lord, page 66. Handle- you go to handle it. Here. Huh? 66, the Supreme Court order, my lord. Especially petition is accordingly dismissed. The petitioner is however granted LOC got it, my lord?
Yes. Who went to Supreme Court?
I went.
Okay.
Petitioner have granted time till 30th April 2009 to vacate the premises in question upon filing undertaking to the effect that this court will ordain 4 weeks from today. He directed that in case the petitioner fails to vacate the premises in question within the aforesaid time, it would be open to a decree holder to file an application before the executing court to the effect that petitioner has not vacated the premises in question within the time granted by this court. In that eventuality, the executing court is not required to issue any notice to the petitioner and will see the delivery of poison is affected within a period of 15 days from the date of filing of the application. In case for delivery of poison, any armed force is necessary, the same shall be deputed by the Superintendent of Police within 48 hours from the date of requisition is received therefore. It is also directed that in case of anybody else other than the petitioner is found to be poisoned, he shall be dispossessed from the premise. Now, my lord, what happened? We, in the executing court, we submitted an application. My lord. Next page, page 68. That in reference to a judgment decree order so and so, after municipal so and so, review petition so and so, passed by the Guwahati High Court, order special leave appeal so and so, and so. The judgment debtor is going to vacate the premises in question in favor of the decree holder. The judgment debtor has already sent a letter to registered post with AD with a request to receive the possession of the premises in question and the date mentioned therein. The judgment debtor is hereby informed the matter for passing necessary order directing the decree holder to receive the premises in question and to do the needful expenditure. So we have filed the execution petition. If that letter is, you'll also find at page 70. That letter we have referred to here, page 70. In reference to order passed in above reference by the respective court, I am going to vacate the premises in question on 3499, 2009 in favor of in your favor, and I would like to request you to receive the same and do the needful according to the court. So, as per the Supreme Court direction, my lord, I undertook to vacate the same. Now, my lord, they did not come and I vacated the premises. I vacated the premises. Now, but they put the execution petition, my lord, without knowingly that we have already vacated on 34. Then Executive Court has passed an order, my lord, that is at page 71. The writ has been issued by the Executive Court. And this is much later than my lord, yes. It appears on 17/8, my lord. Now, on that basis, my lord, the Nazir went there, my lord. If you'll also see page 73, my lord. Bottom, my lord. Aji iman tarike, sotto decree on 18/5, my lord. But we have vacated the permission 34. Decree so and so pronounce Hoka Nide Kunwari, Tinjon Jarikaro Krame, so and so post police repair, Hodge got the still Jate, decrees out, God, that is some idea hoy. Decrees are Hondusti hoy pronoun, decrees record ye, Logota Dujan Stanio, Paki possessive, police repair, a cycle law hole. The next side, my lord, if you also see, বিশেষ দ্রষ্টব্য উল্লেখযোগ্য যে এই পরোয়ানা কার্যকৰী কৰাৰ সময়ত যেন উৎকৃষ্ট উপস্থিত পোৱা নগল গতিকে আদালতৰ হুকুম মতে
উক্ত স্থলত উপস্থিত পোৱা নগল।
yes
That has not been read out.
I have read that.
No, is missing. The video will explain that.
গতিকে আদালতৰ হুকুম মতে টেন্ডাৰ অনুপস্থিত ঘৰ আৰু মাটি ঠিকাদাৰক সমঝাই দিয়া হ'ল। So, madam, we vacated the premises on 34/2009. So that is why we are not there, madam. We asked him to take position on strength with it. Then, madam, we filed a petition there, madam, for external position because as per the direction of the Honorable Court, he had to make construction, madam. Then we filed a contempt also, nothing has happened. Then in the execution case, madam, we filed a petition under Order 21, Rule 11 of the CPC, page 78. Madam. Then, madam, the executing court, madam,
What is this petition?
madam,
Under Order 21, Rule 11,
madam,
what prayer was
yeah,
made?
madam, I'm-
No, you need not to read it. You may tell me.
My lord.
83. It is therefore prayed that the honor may be pleased to pass an order for execution of decree and re-deliver possession of the suit premises with the construction, whatever is constructed on the said land, the petitioner through civil magistrate. Because here, well, we have submitted the position on the ground that he will reconstruct the same within a short time. He did not construct his small house has been constructed and he started doing business there. He did not give a portion to me, my lord. So that is why we submitted this application. Ultimately, my lord, the matter was heard and the judge passed the order which is at page 99. Madam, the last portion, madam, on which madam I have come here, the leave petition they have referred to. Then,
Which, this order you are impugning?
madam, that order is not necessary, madam, because para 14,
Hearing at page 100, my lord. That is being assailed.
page 114, para 14, madam. As the applicants Bimla Todi, Kishore Kumar Agarwala, Rajkumar Agarwala sought for permission from the Honorable Court for clarification and modification of the order at this so in the past approved direction, plenty complies the terms and conditions of the consent agreement entered into by the parties and endorsed by the Honorable High Court, Guwahati so and so, subsequently by order so and so, consequently proceed by giving adequate notice to the applicant in terms of agreement and thereafter complying with the other clauses agreed to therein between the parties. The Honorable Apex Court, however, was pleased not to grant permission to file interpretive application. The review petition number so and so, review petition number so and so, Honorable Supreme Court order that the order of which review has been sought does not suffer from any error apparent warranting its reconsideration, and review petitions are dismissed. In title execution case number so and so was filed by the decree holder, stating that although judges were to vacate the suit premises on or before 34, they did not vacate. Well, this is wrong, madam. Is what I am submitting. Did not vacate the same, therefore it may be issued accordingly. Madam, because we have submitted the application in the executive court as well as issued notice. The copy of the notice was also enclosed to the execution petition filed in the executive court. Though the petitioner Ramesh Kumar filed the affidavit come undertaking for vacating the premises in dispute by the time granted by the Honorable Court on 27/4/2009, JD filed one petition that he is going to vacate the premises in question in favor of decree holder. But from the record of the title execution case number, so it has seen that despite the order of the Honorable Supreme Court, the possession of suit premises not handed over to the decree holder on or before 34/2009. Madam, this is absolutely perverse, madam, what I am saying. This is perverse. And that the possession of suit premises was delivered to a decree holder by Civil Nazir on 18/5/2009 in execution of the deed by this court by order number so and so in that on application filed by the decree holder as per direction of the Honorable Supreme Court. In the report, Civil Nazir, it is stated that on 18/5, he along with the Jadikaro went to a schedule along with the police team and delivered premises and land to a decree holder. The relevant portion of the dated so and so past execution case number so and so in the in the report to Nazir, executing court decrees delivering position should be assessed. Accordingly, the case is hereby disposed of. Again, thereafter, the petitioner Ramesh Kumar Agarwala preferred contempt proceeding. My lord, this is not necessary. Now, 18. The entire chain of events discussed here above reflect that the petitioner has not complied with his part of the agreed condition to vacate the suit premises within the agreed period of 3 months advance notice, which amounted to non-compliance of the order dated 5/4/2006. Accordingly, respondent decree holder who in case of such non-compliance was given the authority to put the decree in execution has filed the execution case number so and so for execution of decree passed in title suit number so and so, and the possession of suit premises was handed over the decree holder in execution. In execution of the deed on application dated 2/5/2009 by the decree holder as per direction of the Supreme Court. Title execution case number 14 was for execution of the judgment dated 14/3/98, and the decree signed on 1998 accordingly disposed of on satisfaction. Once the original decree has been satisfied, there remains nothing for execution. The suit premises was not vacated as per clause 1 of the consent order 5/4/2006, but in pursuance to the filing of the execution case for execution of the original decree as per last part of clause 2, order so and so 5/4/2006 passed by the Honorable Guwahati High Court, and as per the direction of the Supreme Court passed in special leave petition as elaborately discussed above. Now, the JD date for execution of the decree and the decree passed in title has already been executed. There remains nothing more to be executed. The other part is seen that petition to file for execution of the decree was not in a proper format as prescribed by the Honorable Guwahati High Court rules and orders. Chapter 10, Rule 144 stating that for execution application shall be made in form J43. Also, it was not only part of 6 years after suit premises was vacated. The petitioner came with a petition for re-delivery of the possession suit premises to him. As per section 5(3) of the Assam Urban Land Control Act, where the landlord requires possession of a house from a tenant on the ground that house is bona fide required by him for the purpose of repairs or rebuilding or for his own occupation or for the occupation of any person for whose benefit the house is held, and the repairs or rebuilding of the house is not commenced or the house is not occupied by the landlord on such person or such person within 15 days from the date of vacation of the house by such tenant, or house having been so occupied is within 6 months from the date of relet or allowed to be possessed by another person, the court may application on the eviction evicted made with 7 months of vacating the house, direct the landlord to put the evicted tenant in possession of the house within such period as may be as court may fix, and to pay him such compensation as appears to the court to be reasonable and proper. Such direction shall be deemed to be decree under the code of civil procedure and capable of execution as such the provision of that code. Hence, for redelivery of possession, the limitation period is 7 months from the date of vacating the house and not 12 years. In that count, it is found that petitions barred by limitation. So the above aspect where for so and so is rejected in the light of discussion here above does not seem fit to register the petition and order for redelivery of the possession to the suit premises to so and so. So it is held to be barred, my lord. My lord, it is not a question of, my lord, here that we have delivered him just to construction. Here there is a direction, my lord, that he will make a reconstruction within a reasonable period of time and thereafter give a portion to me, my lord, on the fair rent. Here he has not constructed the building, my lord. A small, some type house has been constructed and occupied by himself. This 5T will not be applicable here, my lord. 5T is a case, my lord, where he has taken it for construction for own purpose and thereafter he did not do it. That is not the case. Here, specific order was there that after getting, he will issue the notice to the landlord and that after 3 months notice, then we shall vacate it. Before 15 days of his starting of reconstruction. Here that is not so. And Supreme Court directed on 34, my lord, 34.
On what basis you are reclaiming the possession?
I am claiming the position, my lord, that as per the direction of Supreme Court, our High Court, my lord, that he will make construction and give equal area to me on fair rent. That is the, my lord. That is the question, my lord. And Supreme Court directed on 34/2009, and I have vacated on 34/2009. Nazi report has not been seen properly, my lord. Especially it was mentioned that nobody was there. And we have given a notice to him, my lord. We did not have gone for execution because we have issued a notice to him saying that on 34/2009, I am vacating it. Please take the position. And in this aspect, my lord, that I have already filed a petition, my lord, that I have referred to at page 68. Page 68 and 69. That is important, my lord. 68 and 70.
No, the order, original order of 2004 was
Yes.
that in the event he complete construction, then he will be offering, landlord would be offering an equal area. But here you are submitting that no such construction has been made.
No, that is the matter. That is what I am.
Then under what provision you are reclaiming?
Well, that
The position.
that was a consent order. As per him, as per this, my lord, they have to construct it. Otherwise, they cannot vacate me, my lord. They cannot take position.
Then why 5.4 would not be applicable?
No, 5 will not be applicable because look, superior. Well, that will not be applicable because that is a case, my lord, where there is not a court order, my lord, that is a court order for only for their position, my lord, for their own use, for own use. But here it is not for own use only. That is only for own use, my lord, the losses seen. Here it is a case where, my lord, court order was there that they will make reconstruction. Rest he will take it. Only, my lord, I shall be given equal portion, my lord, on fair rent. I am asking for that only, my lord. That is the question. So when he has not constructed, that is why I filed a petition order 21. So
You
that's
filed petition under order 21 rule
11.
11. Let us see what is that.
That is application for execution.
Order 21 rule
11. We wanted to execute the this order passed by the High Court for the consent decree that they have to.
Rule 11 is for application for execution of
Execution.
decree.
Yeah.
No, where is a decree in your favor?
Consent decree, my lord, that is there, because they will deliver person.
I'll come to you. Where is the decree in your favor?
My lord, decree, my lord, that order itself is a decree, my lord, that is what I am saying. The High Court order, because the original order is merged with that order, my lord.
But
Or
there
the
is
decree
no
was-
such stipulation
My lord,
that there is no such stipulation in the High Court's order
No.
that if the landlord fails to construct building after taking possession, what would happen? That contingency is not taken care of.
no, well, that, only, my lord, I am coming. My lord, at page 76, my lord, the contempt petition we have filed, page 75, my lord, 76, this honorable court has, my lord. You also got it, my lord?
Yes, what,
Yes,
what,
Page 76, the order passed in CRP laid down the condition that landlord tenant for reconstruction and re-entry. The tenant alleges that there is no compliance of the direction passed by the honorable court so and so. Therefore, he has alleged contempt petition against the landlord. The order in question is executable. Well, this is that. Order in question is executable. The question of contempt does not rise. So this honorable court has held, my lord, this order is executable.
now you have to satisfy, is it executable?
Yes, my lord, because this is the direction, my lord, that
Direction is if the landlord construct a,
not if, my lord. Here, my lord, this direction was that he has to construct, my lord, page 45, you will also come. Second para, the landlord shall complete the construction works as speedily as possible without any intentional delay, and so no sooner the construction is completed, respondent landlord shall offer the revision petitioner tenant the proportionate equivalent area which the petitioner is occupying on the date of reconstruction should be subject to payment of fair rent. So this is, my lord, not that if, my lord, if he is not there, he has to reconstruct. And that was the ground I vacated the premises. That was the, my lord, agreement.
does the landlord shall please read clause 2 again. The landlord shall complete. No, it does not stipulate what would happen if the landlord fails to construct the house.
Well, that is why, my lord, this honorable court held that this is already executable. That's why there will be no remedy. That is why we filed a contempt, that there is a violation of the court's order. Then the honorable chief justice held that, my lord, that the order in question is executable.
Now you explain how to execute, which portion to execute.
Now, which portion is, my lord, that he has to redeliver the portion.
Where is that stipulation? There is no such
No,
stipulation.
that is as per rent contract.
Stipulation is if you fail to hand over possession,
Yeah.
then execution may be filed.
My lord,
But there is no other stipulation in that order that if you fail to, if the landlord fails to construct the house, what
my
would,
lord, that was a mandatory order, my lord. that he has to, without intentional delay, he has to complete the construction.
No, but if you put something to execution, that order has to be clear, the decree has to be clear, which is put into execution. Where is that stipulation that if he fails to construct house, the land has to be
Well,
delivered?
that section 5(3) says, my lord, that if it is done, my lord, it can be.
Then if you bring section 5(3) of Assam
done.
urban areas, then the question of limitation and other issues.
Limitation, my lord, that was a, my lord, because we have to read both the, my lord, this High Court order along with the, my lord, section 5(3). Not only alone, my lord, because that was a case where only, my lord, they take away the property for their own use. But here, it was for their own use as well as to give a portion to me. So we have to harmonize, my lord, both the High Court order along with the section 5(3).
What is the error in the impugn order dated?
It says that 6 months limitation, because that provides, my lord, 6 month limitation. But here, he has made a construction, my lord, Assam type house and started his work. He has not made any that RCC, my lord, construction to give it to me. Even in the Assam type house also, I am entitled to, my lord, equal portion. Because it there.
Okay, anything else?
This is my lord, my-
Yes.
If your lordship may kindly turn to the order dated 24/9/2025, passed by this honorable court in the instant matter. Here, I wish to place
24, 24,
9/25, passed by this honorable court. Fraud
Yeah.
will be the preliminary issue which will be heard by this honorable court. If the petitioner can overcome that, well, then I will enter into the merits of the matter.
it is there on record. What you want to indicate?
This fraud thought to be perpetrated on this honorable court, as well as the learned court below. If the lordship will kindly come to page 70. of
No, what this order says, 24/9/2020.
and the preliminary issue. How fraud has been perpetrated by the petitioner before I enter into merits this case.
Okay,
Most humbly draw your lordship's attention to page 78 of your lordship's brief. That is the application before the learned court below, filed on 19/10/2015, which came to be dismissed by the learned court below in the order impugned.
Yeah.
Here, my lord, there is no reference to the order dated 13, the judgment in order dated 13/10/2008, passed by the learned Supreme Court in their SLP. It is their own SLP. Against the revision filed before the honorable court, which was directed against the order passed in execution. So that is the first count. And the second count, why this is fraud. So, and I think the place reliance on S.P. Chengalvaraya and Naidu's case, 1990.
no, before you go to judgment, you first tell me the facts, why you are alleging fraud.
States that the fact that the Honorable Supreme Court had passed the judgment in order dated 13/10/2008, which put a quietus to the entire list. That does not find place, pages 78, 79, 80, 81, 82, and 83.
Okay,
Then, well, the next angle is the petitioner has repeatedly relied on page 45. If I may draw your lordship's attention to page 45, 46 of your lordship's brief.
Yes.
The last line, my lord. It is needless to say that the current rent and the arrear rent, if any, will also be paid to the landlord by the tenant. That, in my humble submission, has not been paid. Why? The Royal Lordship attention paid it 215 to 218 of your lordship's. Will you- By one Kishore Agarwal.
Page number?
Has not been tendered. Miscellaneous NJ case 423 of 2009. This was filed after they were not found present. On the seventh day of May, no, a few days before they were not found present by the LBA. 216 on the seventh day of May 2009. But this is by Kishore Agarwal. Kishore Agarwal's name has been deleted from the proceedings before this honorable court. And it kindly comes to page 43 of the lordship.
No, what this 215 indicate?
They have not deposited a single farthing towards rent till date, since the date of the decree on the 4th of March, 1998. That was the reciprocal part, their reciprocal arrangement. They have not adhered to that. They are silent. They say they rely on these pages 215 to 218. A man whose name has been deleted from the proceedings before this honorable court. Lordship, may kindly turn to page 43 of your lordship. Page 43 to the end. Has the lordship got it?
Yes.
Page 43, refer honorable court's order. This is their petition, my lord. In their petition. Their CRP, my lord. Names of performer respondents, 3 to 11, deleted. And Kishore Agarwal is number 3. Lordship got it.
No, what you want to emphasize?
6. Relied on by the petition.
That they have paid rent.
Yes. That is another fraud sought to be perpetrated on this honor. If they can overcome that, my lord, I shall enter. My learned senior colleague may respond.
My lord, that was not the plea taken before the executive court by them, my lord. That was not the, in the order, my lord. And what they have said, my lord, that we have submitted the Supreme Court judgment that is referred to by the executive court at page 117. There we have mentioned it or not, but we have referred to it. Page 117, your lordship will see it, that on Supreme Court already mentioned.
Does not say the JD has placed. Paragraph 19 does not say the JD. Suit premises was not vacated as
No,
per
we have-
clause 1 of the consent order dated 5/4/2006, but in pursuant to the filing of the execution case for execution of the original decree of 1998. As per the last part of clause 2 of the order dated 5/4/2006, passed by the Honorable Guwahati High Court, and as per the direction of the Honorable Supreme Court, passed in so and so as elaborately discussed. Not. That, my lord, is fraud. And the event, this honorable court arrives at a finding that this petition is vitiated by fraud. I pray that a few lakhs may be imposed as costs, exemplary costs, my lord. That will be piffling for the petitioner.
So whether the facts which are not there before the executing court, your lordship may not consider the same, my lord. Because they have not alleged the same before the executing court. And Supreme Court judgment was very much there before the executive court, and he has considered it.
How the executing court came to know about the Supreme Court's order?
My lord, here you will also find at page 130, my lord. That, The Honorable High Court ordered so-and-so petitioner granted 2 months time to make a so-and-so on failure to vacate premises. The landlord will be entitled to put the decline. Against the said order, the petitioner again preferred so-and-so. So that is, we have submitted our argument. Honorable Supreme Court and Supreme Court High Court order so-and-so was pleased to pass the order so-and-so. This was quoted.
So the executing court was in the know of the fact
Yes.
that but then nothing was suppressed. The court was knowing the fact that the matter.
That they have not placed in their petition before the learned
No,
court.
if it is otherwise known to the court,
They have not placed.
okay, okay.
That they have not placed has been held by the Honorable Supreme Court in Chegalbarai Naidu's case, 1994, 1 SCC 1.
Suppose a fact is otherwise known to the court and a party fails to mention that fact in its petition,
That's what the Honorable Supreme Court says.
would it amount to suppression of facts?
Non-mentioning, even non-mentioning of the release deed at the trial is tantamount to plain fraud. Here
Right.
it is passed by the Honorable Supreme Court.
No, in what context that Supreme Court made some,
For the learned trial court before obtaining a decree in their favor. A fraud is an act of deliberate deception with the design of securing something by taking unfair advantage of another. It is a deception in order to gain by another
No.
loss.
Ms. Sharma, if something is known to you, is it necessary, if there are materials to indicate that this fact is known to the court, is it necessary?
It's for the Honorable Court. Well, they have not, it was
No,
incumbent.
that is my query to you. How the court has mentioned about Supreme Court's order in its, therefore I asked, what is there to indicate from, okay, okay, I understood your submission. I'll consider that.
Anything, any material on record that they have complied with the reciprocal part of their obligations spelled out in the order dated 25/4/2006 that they seek to place reliance on. And what they seek to place reliance on is one piece of document, my lord, which we have placed. They have not paid one farthing, my lord, after the order, the decree came to be passed. Not a penny, my lord. And whoever is paid, my lord, that is Kishore Kumar Agarwala. His name has been struck off from the records. I have placed my lord, from the proceedings before this on report at page 43. That is their conduct. And my lord, he is a multiple landholder. My lord, kindly come to page
Okay, address on merits now, I'll consider.
of 1958, title suit 2, renumbered. Finally, it was decreed in favor of the decree holder company. This is Annexure A, pages 150 to 114 of your lordship's decree on the 4th of March, 1990. Has your lordship got it?
No, we need not to go into that aspect.
Yes.
The
Yes.
to
I will
the-
come. The 5/4/2006 order. madam.
yes, that is relevant.
Again, go back. The 5/4/2006 order. first is reconstruction and has fallen from this honorable court. There is nothing if they don't construct. Page 46. With the aforesaid revision clause stands closed in terms of the conditions as agreed between the parties.
No, their main contention is that the executing court dismissed the application under Rule 2111 on the ground that it is barred by limitation. And the decree has been already executed. There remains nothing.
That is, there is no infirmity with the judgment impugned before this honorable, the order impugned before this honorable court.
No, how will you address the submission of learned senior counsel that the court has not taken into consideration that the decree was a consent decree? That it was for the landlord to construct the building and give a share, appropriate share.
Date, the land was handed over to the decree holder. Page 73, where Nazir says, Kaku Nepaluma, posted one over Kaku. So, my lord, they had not vacated. That is my first contention. They had not vacated the land. They were not present. And then, second limit, they had time, my lord. It is the Urban Areas Rent Control Act under section 5(3). The period of limitation is prescribed. They have chosen not to follow that. They could have very well filed a petition there in the learned court below. Within 7 months from that, they have not. There was no reason for them to wait till 2000, when did they file? 2015, Miller. They could have filed for repossession.
Urban Areas Rent Control Act. Please read section 5 clause 3.
May I?
Yes.
When the land covers possession of a house from a tenant on the ground that the house is bona fide required for purpose of repairs or following, or for his own occupation, or for the occupation of any other person for whose benefit the house is held, and the repairs of the or the rebuilding of the house is not commenced, or the house is not occupied by the landlord, or such person within 15 days of the date of vacation of the house by such tenant, or the house having been so occupied is within 6 months of the said date relet to others, or relet to or allowed to be possessed by other person, any other person, court may, on the application of the evicted tenant made within 7 months of the that they have chosen not to do, take the entire system for a ride by filing one petition after another. If they have not, well, the limitation, this is a special piece of legislation. They must adhere to it. If they have not, they have not, my lord. They are out of court, my lord. And if an argument is sought to be advanced that this would not apply, my answer would be a question to myself, would it be the law of the jungle? If it is not Urban Areas Rent Control Act. It is all along under the Urban Areas Rent Control Act that the suit came to be filed in 1958. All along the decree being issued in favor of the company. And they coming to this honorable court and then finally to the Honorable Supreme Court. It is they have chosen not to adhere to the statutory provisions. Take the legal system make it run around its little finger. That is what they have done. Oh, well, this application cannot withstand scrutiny of this honorable court on that count, that they have themselves not adhered to the statute. My humble apologies.
One and submitting, my lord, regarding, my lord, the non-payment of rent, we have specially denied it and said that we have entire rent has been paid in para 7 of our reply. Para 7 of our reply. My lord. And secondly, my lord,
Paragraph 18 of the judgment impute. The
uh,
entire chain of events discussed here in above reflects that the petitioner had not complied with his part of the agreed condition to vacate, and within the period after receipt of 3 months advance notice, because amounted to non-compliance.
Okay. Heard
my lord,
In-
this is the, my lord, because our application for the executing court as well as the letter issued to them by registered post, my lord. And we have vacated it, and when the report of the Nazir also shows that no, we're not there. Nobody is there. We have vacated it. When they went there on 18/5, my lord, nobody was there. So there is no question of, my lord, any violation of the order. Because executing court was very much known that, my lord, we were vacating the premises on 30.
Stall out Puano Goldman. They had not vacated. I stand by that face.
The roots will be there, otherwise.
Before the song.
I'm reserving the order.
Man.
Heard Mr. G. N. Sahewala, London, Senior Counsel assisted by Ms. S. Todi, London Counsel for the petitioner. Also heard Ms. S. Sharma, London Counsel for the respondent. Hearing concluded, judgment reserved.
Much.
Lagi.
Is a lordship. This medical is filed against the judgment and order passed by the learned district judge Sibsagar lordship. Actually, lordship petitioner and respondent both filed mutual divorce petition before the district judge lordship, and divorce has been allowed. And in the divorce petition lordship, respondent specifically stated that she will not claim any alimony from the opposite party lordship, but learned
None has appeared for the applicant on call. It also appears that no steps for issuance of notice on the respondent has been taken by the applicant as was directed by this court. Considering the above facts, let this matter be listed again in the first week of January on a date to be fixed by the registry.
Item 6.
No. At the line, the petition, the applicant is directed to comply with the directions of this court within a week from the date of this order. Let this matter be listed in the first week of January. Yes.
Lordship, matter will be passed over for time being as the council is on legs, my lord. Obliged.
In item 4, Madam, I am appearing for the state of Arunachal Pradesh. Today, Madam, I am slightly ill. Madam.
Item number? Now record. What is the matter here?
1985, claiming monetary benefit, which were supplied by us. The financial amount were not given to us, so I filed a minor.
It was decreed.
Suit was defeated. Thereafter, the appeal was filed by both the parties,
By the
What?
state?
by the state against the degree, judgment and degree, and by the
20.
plaintiff for the
Quantum
interest part,
interest.
for the interest. Because interest was claimed, say 18%, it was given 6% or something like that. Now the state, because it was from, at that time, NEPA was there. The cost started, the cause of action started in 1953 and
This is a very old pending
Oh,
case.
I'm sorry for that. I'm seriously ill.
No, we are allowing your prayer.
85 suit, my lord. 2005 appeal, my lord. I understand that.
parties there. Some order. It was dated
28,
2024.
2024.
Certain parts of the paper route is not legible and certain parts are not tagged with the. So it was raised to the to verify the documents and as well as it was.
Paper book of the trial court records.
Yes. Paragraph number 3, 58, 2024.
Okay. What is your name?
M.R. Adhikar. M.R. Adhikar.
Heard Mr. M.R. Adhikari. Additional
Senior government advocate.
senior government advocate. Government of Arunachal Pradesh. Appearing for the appellant in RFA number 138/2025 and respondent in RFA number 140/2025.
2005.
2005, sorry, 2005. Also heard Mr. P. Hajurika,
MK Mishra.
M.K. Mishra. Learned counsel for respondent number. In first suit, you are respondent number 1.
1.
Respondent number 1 in RFA number 138/2005, as well as appellant in RFA number 140/2005. Also, Miss M. K.C., learned government advocate, Nagaland, appearing for the state of Nagaland in both the cases. Why Nagaland is party?
At that time, it was entire part was there and for some cause of action arose at that time Nagaland, but after bifurcation they have.
Stop. Mr. Mishra, learned counsel, learned senior government advocate appearing for state of Arunachal Pradesh. Sorry, Mr. Adhikari, learned senior government advocate appearing for the state of Nagaland has prayed for an adjournment. State of Arunachal Pradesh has prayed for an adjournment on the ground that he is not well today. Considering these submissions made by the learned counsel, the counsel for other side have raised no objection. Stop. Though this is an all pending, these appeals are all pending in the year 2005. However, considering the ground, the prayer is allowed. Moreover, Moreover, learned government advocate Nagaland has also submitted that she has not been furnished, she has not yet received the paper book of trial court records prepared by the registry. The registry is directed to furnish a copy of paper book of the trial court records. After rectifying the defects as was pointed out by this court in its order dated 28/2024. Stop. Next, though these appeals are very old pending appeals of the year 2005. However, considering the submissions made by learned senior government advocate Arunachal Pradesh, as well as the circumstances indicated herein above, the prayer for adjournment is allowed. Let this matter be listed in the in the first week of February on a date to be fixed by registry as fixed item.
Item 6.
May please your lordship, senior advocate Mr. G.N. Sahil on legs in court number 8 lordship. Matter will be possible for a time being.
Okay.
All right.
Item 7.
Secondable appeal, my lord. Reversal, my lord. It was the defendant, my lord, in the suit, my lord. Initially, suit was dismissed, my lord, against the plaintiff. In the appeal, my lord.
What was suit was for?
Suit was for a declaration of right title interest, my lord, on the basis of a gift, my lord. That has been rejected, my lord, by the court below, my lord. Then, my lord, the preferred appeal in the appeal, my lord, it was reversed, my lord.
You were the plaintiff.
I was the defendant, my lord.
You were defendant.
The defendant. My lord, substantial question of law formulated on 18/2/2015, my lord. While admitting this appeal, my lord. Two substantial questions of law. 18/2/2015, my lord.
Yes.
Whether the learned court below misconstrued the mandate of section 123 of the Transfer of Property Act pertaining to valid gift of immovable property and thereby illegally decreed the suit. Whether the plaintiff's suit being one for partition of ancestral property was barred by non-joinder of necessary parties in the form of other legal heirs of the Fotichandra Bora.
But what substantial question of law is there in these questions?
My lord, regarding the first one, my lord. First one has been framed because, my lord, the suit they have filed, my lord, was on the base, they have said that, my lord, the suit property was, half of the suit property was gifted to them by their father, my lord. But without, my lord, adducing any gift deed, my lord. On that ground, my lord, the suit was originally dismissed, my lord. But while preferring the appeal, my lord, court has gone on to a different, my lord, fact, my lord, which is not pleaded case of the plaintiff. Court has gone as if the suit is for partition suit, my lord. Therefore, my lord, the plaintiff was given half of the share of the, my lord, suit. But the base of the plaintiff was that, my lord, the land was gifted to them, my lord. This may read the judgment of the.
What is section 123?
123, my lord, requirements of the. Requirement of a valid gift deed, my lord.
But the way the question number 1 has been formulated, we have to go into facts.
My lord.
Is it a substantial question of law
My lord.
only?
That has to be seen, my lord.
But on a bare perusal, it appears that unless we go into facts, this question cannot be decided.
My lord.
Whether that can be done at this second appellate stage.
my lord, but the substantial question of law has been framed on the basis of the facts, my lord.
Now we, in the second appeal, we have to decide whether actually it has been formulated,
My lord,
but the other side may still plead that there is no such substantial
lord.
question of law.
obviously, my lord. One
So
point,
before the other side pleads,
my lord,
I am putting query to you
my lord,
that the way this question has been formulated,
my lord,
that the trial court has misconstrued the mandate of 123
my lord,
to decide on either side. You have to go look into facts.
Hello.
You have to consider the facts. Then whether it remains a substantial
my
question.
lord. My lord, if in my humble submission, my lord, if your lordship goes to the judgment of the Munsif court, my lord, first in the suit, my lord, there is only 4 pages judgment, my lord. That will make everything clear, my lord. May I read that judgment, my
Which page?
My lord? Page it starts from page 24 of the appeal memo, my lord. It will come to 25 directly, my lord. This will make my lord entire thing clear, my lord. What facts, my lord? May I read, my lord?
Just a minute.
25, my lord. Just a minute. Oh, sorry, my lord. That is title appeal, my lord. 16, my lord. Judgment of the suit, my lord. Whereby the suit of the plaintiff was dismissed, my lord.
Yes,
May I read, my lord?
yes.
Paragraph 1, my lord. The plaintiff case in brief is as follows. That the plaintiff and the defendant are 2 sons of late Photik Bora, and that after the death of Photik Bora, his property devolved upon his 4 sons, including the plaintiff, defendant, and his wife. Late Photik Bora, however, during his lifetime gave share of his landed property to his daughters also. It is the further case of the plaintiff that the landed property consisting of the residential house of their father, which is more specifically described in the schedule of the plaintiff, has been gifted to both him as well as the defendant equally in 2 parts after giving delivery of possession. However, after the death of Photik Bora, the defendant illegally occupied the above suit property, and in spite of repeated requests, the defendant refused to vacate the plaintiff's portion and even did not allow the plaintiff to enter into his portion. Hence, the instant suit wherein the plaintiffs prayed for a decree declaring half share of his scheduled property along with consequential relief of partition, a decree of permanent injunction, and other reliefs the plaintiff is entitled to. Paragraph 2. The defendant entered appearance and filed written statements stating that there is no cause of action for the suit, is not maintainable, is barred by law of limitation, is bad for non-gender of necessary parties, is not properly valued, etc. The defendant denied the allegations made by the plaintiff and stated that no deed of gift was executed by their father. The defendant claimed that after the death of their father, he, along with other 3 brothers, got separated, and all of them used to reside in separate landed property of their father, and that he used to possess the suit property by residing thereon with his family. It is further claimed that he has filed a suit against the plaintiff in respect of a plot of land at Jokhalavana town. The plaintiff has filed the instant suit. Paragraph 3. Based on the pleadings of both the parties, my learned predecessor in the Chair White order dated 21/1/2012 framed the following issues. Whether there is cause of action for the suit, whether the suit is maintainable in its present form, whether the suit is barred by law of limitation, whether the suit is bad for non-gender of necessary parties, whether the suit property is valued and proper court fee has been paid. 6. Whether the plaintiff is entitled to decree of half share over the suit property with consequential relief of possession and separate possession of the land and buildings described in the schedule of the plaintiff equally into 2 parts by evicting the defendant from the plaintiff's half share. Whether the plaintiff is entitled to the decree of permanent injunction as paid for in respect of suit land and building. What are the reliefs and reliefs? Paragraph 4, the plaintiff side, in order to prove his case, examined 3 witnesses and has also exhibited some documents. The defendant examined himself and also exhibited some documents in support of his case. Both the sides cross-examined each other, others witness. I have heard arguments forwarded by learned counsel of both the sides. Defendant side has also submitted written argument in support of his case. My decision on the issues are as follows. Issue number 1, the allegations and counter allegations level against each other have led to the filing of this instant suit wherein both the parties have led evidence in support of their respective cases. In view of the same, I am of the measured view that there is cause of action for filing the suit, but whether the plaintiff succeeds in proving the cause of action will be discussed in the subsequent issues. The instance should be issue number 2. The instance should be one filed for declaration and partition. The same is maintainable in the civil court as the civil court is appropriate forum. Moreover, defendant side has failed to show any reason for which the suit is not maintainable in this court. The issue as such is decided in favor of the plaintiff. Issue number 3, instance issue has not been pressed at the time of argument, and further there is nothing to hold that the suit is barred by limitation. Now, issue number 4, that is relevant, my lord. The defendant in his written statement has pleaded that non-joinder of all the legal heirs of late Phatik Bora has made the suit bad. The instant suit has been brought by the plaintiff against the defendant, claiming a joint title over the suit property on the basis of same being gifted to him and the defendant by their father. Hence, in the above circumstances, the other heirs of late Phatik Bora cannot be said to be necessary parties in the instant suit, and the issue as such decided in favor of the plaintiff. Now, issue number 5, the instant suit is one for declaration of consequential relief of partition injunction. Plaintiff has valued the suit so and so. Then relevant issue number 6, my lord. The vital issue, my lord. The plaintiff in the instant suit has claimed his half share in the property on the basis of gift being made to him and the defendant by their father, and the plaintiff has relied on Jamabandi copy exhibit 1. The plaintiff in his evidence claimed that their father did not execute any gift deed in their favor. The defendant, on the other hand, claimed that no gift deed has been executed by their father. The plea of the plaintiff that no gift deed has been executed in their father has, however, been contradicted by PW3 Latmandan, who has exhibited and proved the Sitha of Sotial village exhibit 10. In his evidence, PW3 stated that in exhibit 10, it is mentioned that both the plaintiff and the defendant has been gifted the land covered by Dag number so-and-so, PP number so-and-so by way of 2 registered gift deeds by their father, late Phatik Bora. In the instant case, plaintiff has, however, not produced deed of gift and has based his claim on the strength of mutation of his name on the Jamabandi, that is exhibit 1. Section 123 of the Transfer of Property Act states that for affecting a gift of immovable property, transfer must be effected by a registered instrument signed by or on behalf of the donor and attested by at least 2 witnesses. The same is lacking in the instant case. Mere mutation of the plaintiff in the Jamabandi without the document of title will not enable the plaintiff to get a title over the suit property. The plea of gift having remained unproved, the plaintiff is not entitled to get any relief. Because of what has been discussed in the issue number 6, the plaintiff is not entitled to any of the reliefs as claimed, my lord. And the plaintiff suit has been dismissed, my lord. Now, my lord, in the appeal, my lord, the first appellate court, my lord, it has done, my lord, which is not pleaded case of the plaintiff, my lord, court has gone into an assumption that, my lord, it is a suit of partition, my lord. And since it's a joint property, my lord, he has been given half share of the property, my lord. And if that be the case, my lord, the other legal layers are necessary parties, my lord. Because in the suit, my lord, court has specifically stated, since the suit is based on the gift deed, my lord, it's not bad for non-gender of necessary parties for non-inclusion of other legal layers. Now, the first appellate court, my lord, without there being any pleaded case that it's a suit of partition, my lord, gone as if, my lord, it's a suit of partition, my lord, and allowed half share to this plaintiff, my lord, but without reversing that issue, my lord. The suit is not bad for non-gender of necessary parties. If it's a suit for partition, my lord, which is not the case of the plaintiff, my lord, then, my lord, it is fatal for non-gender of necessary parties, because other 2, my lord, brothers and sisters, they were not made parties, my lord. And it's a clear case of the plaintiff, my lord. Your lordship goes to page 11, my lord. Page 7 of the, my lord, they plaint, my lord. Page 7 at appeal memo, my lord. Specifically stated that the scheduled property is exclusive property of the plaintiff and defendant jointly as gifted property from their father. They have not, my lord, claimed the right of partition, man. And when, my lord, The plaintiff is based on gift deed, my lord. The gift deed has to be proved, my lord. They have not produced any gift deed, my lord, whatsoever, my lord. And that's why, my lord, the first substantial question of law was framed, my lord. And the second substantial question of law was framed because, my lord, since the appellate court has taken it as a partition suit, my lord, has granted half share to the plaintiff, my lord. And if that be so, my lord, then it's a suit is bad for non-gender necessary parties, my lord, for non-inclusion of other legal heirs, my lord. In both ways, my lord, suit is not maintainable, my lord. So in my humble submission, my lord, first, my lord, the judgment passed by the Munsif is totally right on the facts, my lord, facts and evidence, my lord. Because mayor on relying on the Jamabandi, my lord, court cannot help the decide the title of the party, my lord. They are only relying on the Jamabandi, my lord, without producing any gift deed, my lord, whatsoever. Not to speak of proving that, my lord, they have
No,
not produced any
what
gift
is
deed,
the difference
my lord.
between a first appeal and a second appeal?
Well, there has to be a substantial question of law, my lord. And this, my lord, the first appellate court has, my lord, heard in, my lord, reversing the judgment, my lord. That to, my lord, which is not a pleaded case of the plaintiff, my lord. The plaintiff never stated that, my lord, they are seeking their right by way of partition, my lord. Specifically, they are stating in the plain that, my lord, this has been gifted by their father. If they gifted, my lord, where is the gift deed, my lord? Then, my lord, section 23 has to be, my lord. Requirement of section 123 has to be fulfilled, my lord. Neither gift deed is registered gift deed is there, my lord, nor, my lord, possession has been delivered, my lord. So in my humble submission, my lord, the learned Munsif has held it rightly, my lord.
Where is the decision of the first appellate
First
court?
appellate court is at, my lord, page 24, my lord. I can skip the, my lord, earlier portion, my lord, and directly come to page 30, my lord, decision and discussion, my lord.
Yes. Please read para 15.
Yes, my lord. From the pleadings of the party, it is seen that Fotik Chandra Bora was the original owner of the suit land, which is measuring 2 bigha 12 acres with 2-story wooden residential building with 5 rooms, in each story, including bathroom, latrine, water system, electricity connection, with front side boundary wall with an iron gate. The suit property is situated at Village Hotel, Kisam Moja Hotel, and land is covered by Dag number so-and-so, Patta number so-and-so. According to the parties, Fotik Chandra Bora died in the year 1987, leaving 4 sons, 2 daughters. It is mentioned in the plain that after death of Fotik Chandra Bora, his all property is devolved on his 4 sons and his wife, and after death of his wife, her share also devolved on the 4 sons and daughter of Fotik Chandra Bora got their share of landed properties during his lifetime. Admittedly, Fotik Chandra Bora was the owner of the suit properties, so by right of inheritance, plaintiff is also entitled to a share of properties left by his deceased father, Fotik Chandra Bora. As the suit properties originally belonged to his father, late Fotik Chandra Bora, so thus by right of inheritance under Hindu succession, plaintiff being one of the class 1 heir is entitled to equal share in the suit properties with his other brothers. The point raised by the plaintiff appellant is that their father, late Fotik Chandra Bora, gifted suit properties to him and defendant in the year 1980, including equal parts and possession was delivered. Evidence of PW1 Tarinikanta Bora is that they are 4 brothers and 2 sisters and disputed land is their paternal properties. He stated that he has not filed the suit based on a gift deed. He further stated that though his father gifted the suit land, but no gift deed was executed. He further stated that his brother defendant in this case, Hemchandra Bora, filed a suit which is numbered as TS number so-and-so against them, claiming his share of land. Thereafter, he filed the present suit. He further deposed that his father during his lifetime given landed properties to all the brothers and sisters, and accordingly, all of them possessing the same, and his father given him and his elder brothers the old house situated at Satyal. He denied that his father, Fotik Chandra Bora, during his lifetime, in writing, given the suit properties in favor of the defendant Chandra Bora alone. Defendant number 2, Jatin Chandra Bora is that evidence of defendant number 2, PW2, Jatin Chandra Bora is that the defendant and the plaintiff are the sons of late Phatik Chandra Bora, and their father died in the year 1987, leaving him. His brother Hemchandra Bora, Debendranath Bora, plaintiff, and 2 daughters, namely Damayanti and Bhuvaneshwari, and their mother Pratima, and their mother died in the year 1989. He deposed that after death of Phatik Chandra Bora, his all properties devolved upon his 4 sons, and after the death of his wife, her share also devolved upon them, and his father, late Phatik Chandra Bora, is the owner of the suit property. He further deposed that as per Exhibit 1, Phatik Chandra Bora gifted suit property to plaintiff and Hemakanta Bora in 2 parts. In cross, he stated that there are 4 brothers, 2 sisters, and all were got equal share on the father's property, and suit land is their paternal property. He further stated that his father during his lifetime divided landed property to his children, and accordingly he got the properties at Sutial. Plaintiff and Hemchandra Bora got the old house. The plaintiff also got properties in Borbhugia and Jajori, and all these division took place 30 years ago. Evidence of PW3, Dipen Mudoi, is that he is the Lat Mandal of Kuliabar Revenue Circle, and he adduced evidence based on other sita and Jamabandi of the Sut Patta. He deposed that suit land situated in Sutial Kisam and under Sutial Moja Patta number is so and so. Area of the land is 2 bigger 12 acres of the land, and as per Sita, this land is divided into 2 shares having area of 1 bigger 6 acres of land in favor of Tarini and Hemchandra Bora as per gift. As per Sita, gift is made by registered deed number so and so dated 24/9/76. In cross, he stated that without going through the gift deed, he cannot say who has gifted the land in whose favor. Evidence of DW1 Hemchandra Bora is that his father, late Phatik Chandra Bora, and had landed properties measuring 2 bigger 12 acres of land and with 2-story wooden built residential building where he is now residing. He stated that his father never executed any deed of gift and delivered possession, and during lifetime of Phatik Chandra Bora, his 4 sons separated with their own consent, and after death of Phatik Chandra Bora, the said separation was finally effected, and the plaintiff left for Borbhugia near Jokhalabanda, where he had constructed separate residential house in the land belonged to Phatik Chandra Bora. All other sons of late Phatik Chandra Bora had separate and used to reside at separate house of land left by late Phatik Chandra Bora. He stated that his father was a zamindar. He deposed by that they were 4 brothers and 2 sisters, and at the time of their parents, all brothers living in the suit property. Land is 2 bigger 12 acres of land, and there is 2-story building. In cross, he stated that his father during his lifetime gifted some landed properties to all the 4 brothers, and suit land is given to him by his father. He denied that suit land is given to him and his brother Tarini Kanta Bora. He stated that he do not know whether the Exhibit A, it is mentioned that he and Tarini got the property by gift. He stated that he received the notice from the plaintiff and the plaintiff sought his share of land. He stated that there was no partition made on those properties which are not gifted to them by their father. He deposed that the land at Borbhugia where plaintiff constructed his house and staying there is purchased by the plaintiff himself. He deposed that there was no partition filed for partition of the suit land. Oral evidence of the plaintiff and defendant pointed that Phatik Chandra Bora during his lifetime distributed his properties amongst his children. Defendant evidence also revealed that their father, Phatik Chandra Bora, gifted some of the properties to all children where they were residing, and land at Borbhugia where plaintiff is at present residing is purchased by the plaintiff himself. That means that land is not the land of Phatik Chandra Bora. Oral evidence further pointed that the rest of the land which is not divided and distributed amongst the legal heirs of late Phatik Chandra Bora during his lifetime are not yet partitioned among the brothers. Both the parties of the suit claim that daughters of the late Phatik Chandra Bora got their share of properties during their lifetime of Phatik Chandra Bora. In this case, admittedly disputed properties originally belonged to Phatik Chandra Bora, the father of the plaintiff and defendant. Defendant also claimed that suit properties is given to him by his father by executing a gift deed, but to show the same, there is nothing available on record. By right of inheritance, plaintiff has 1 share of land in the suit properties. PW2 is the brother of plaintiff and defendant. He deposed that his father gifted the suit properties equally in between plaintiff and defendant. The plea of the plaintiff and the defendant made in their pleadings and evidence further make it clear that the late Fatih Chandra Bora during his lifetime distributed his properties among the children, and after going through ordered evidence, there is nothing to disbelieve that Fatih Chandra Bora has not distributed his properties among his legal heirs. In the Sutpatta, there is as many as 70 numbers of tak. Total land is 25 biga, 3 katha, 10 lechas. As per Jamabandi, name of Hemkanta Bora mutated in place of Fatih Chandra Bora in the land of tak number 1016 by gift. Name of Devendra Bora mutated in the land of so and so, and name of Jatin Bora mutated in respect of the dag number so and so, and in respect of land dag number so and so, name of Hemokanto, Devendra, Jatin, and Tarini Bora mutated. As per note Go mentioned in the Jamabandi is corrected as per order of circle officer. Name of Hemokanto Bora mutated by gift in respect of land of 1 katha, 7 lechas of land in dag number so and so, photo number.
You can skip this
My
paragraph.
lord, you can skip this paragraph, my lord.
Paragraph
Then
28.
Paragraph 28, my lord. Oral evidence shown that there is an amicable partition took place among the legal heirs of Fatih Chandra Bora, and Fatih Chandra Bora distributed his properties during his lifetime among his children. The Jamabandi copy exhibited by both the parties pointed that Sutpatta land is distributed among the 4 sons of the late Fatih Chandra Bora, and as per distribution, land of dag number so and so fell in the share of plaintiff and defendant. Parties to the suit and the other legal heirs have not disputed their mutation in respect of the land of the Sutpatta in the Jamabandi. The entries of the Jamabandi, which is record of right, is deemed to be correct unless the contrary is proved. And the Jamabandi copy evidence on record shown that the name of legal heirs of Fatih Chandra Bora mutated in respect of each tak as per distribution of the properties of late Fatih Chandra Bora during his lifetime, and therefore I do not find any ambiguity in the entries made in the Jamabandi copy. As per amicable distribution which is made by Fatih Chandra Bora during his lifetime, suit property is distributed on plaintiff and defendant equally. Hence, I hold that the plaintiff is entitled to half share of the suit properties, and he has right title interest in respect of half of the suit property, is and also entitled to partition his share and khas position in respect of half share of the suit property. In the result, I hold that appeal has got merit and interference with the decision of the learned Munsif Koliyabor, and so that is so and so. It's called for and is hereby set aside. The plaintiff is entitled to half share of the suit properties and has right title interest in respect of half of the suit properties, and so entitled to partition of his share and khas position in respect of half share of the suit property. Learned trial court shall issue precept to the revenue authority to cause partition of the suit land. Hence, the appeal is allowed on contest. My
The
lord,
suit property consists of how
2
much?
biga, 12 lechas, my lord. Suit property. And this is pleaded case of both the parties, then there are other properties also, my lord. So let,
Out of 25 biga of Fatih Chandran,
my lord.
only
Already those were partitioned, my lord, and this share fell into the share of defendant, my lord.
2
Now
biga.
they're, in spite of taking their share, my lord, they are also claiming share, half share in this property also, which belong to the defendant, my lord. And when their cases, my lord, the basis of their plaint is right title interest is on gift deed, my lord, without executing any gift deed, my lord. The appellate court has wrongly, my lord, gone into the as if it's a suit of partition, my lord. And if it's a suit of if it can be, it is taken as a suit of partition, my lord, then other legal heirs and all other properties are also required to be, my lord, partition, my lord. You cannot, my lord, say that, my lord, this portion of property he is also entitled, my lord. Since, my lord, he has taken his share already, my lord, as per the evidence, my lord. And when it's not a pleaded case of the plaintiff, my lord, that is a suit for partition, they have specifically stated that, my lord, land has been gifted to them, my lord. But they failed to show any gift deed, my lord. And that's why, my lord, rightly, my lord, the learned Munsif has dismissed their suit, my lord. When you file a suit for seeking a right title interest on the basis of a gift deed, my lord, you have to prove the gift deed, my lord, as stipulated by, my lord, 123 of the Transfer of Property Act, my lord. Nothing is there, my lord.
Okay.
My lord, this is my humble submit. Let me
Yes.
submit, my lord.
So far, my lord, substitution question of law, number 1, my lord. As my lord friend is saying that there is a gift deed it is not registered, they are liable under section 123 of the Trust for Property Act, it to be registered. So as per the statement, whatever is submitted before the first appellate court, that para 10, 11, when the brothers of both the appellant and respondent, elder brother, it is urged by the learned appellant counsel, that which is relied upon by both the parties, the name of the plaintiff, dependent, mutual and equal share in respect of the suit land number.
Which para you are reading?
Para 10 of the appellate order.
Case number.
Page number to पहले दिखेगा ना?
Oh, this.
No,
It is page number for you. It will be moved. Oh, no, even.
What page? What one?
Yes, para 10.
Para 10.
Page
29.
29.
Now, what you want to emphasize?
My lord, there's the only oral gift, which is evident from this record. My lord, there's no any gift deed as per their statement by the made by this.
There is no gift deed.
No gift deed. Since there is a no gift deed, registration of the gift deed does not arise. It is the oral settlement, family settlement of the property. So when this already it is observed in this appellate orders, my lord. This is in para 28. At page 28, my lord, the oral evidence shows that there is an amicable partition took place among the legal heirs of the Fatik Chandra Bora, and Fatik Chandra Bora distribute his property during his lifetime among all children. The Jamabandi copy exhibited by both the parties pointed out that the shoot pata land is distributed among the 4 sons of the late Fatik Chandra Bora, and as per distribution, land of Dag number 782 falls into share of plaintiff and defendant. This is my appellant and respondent. The parties to the suit and the other legal heirs have not disputed their mutation in respect of the other land of the suit patta in the Jamabandi. The entries of
para
the
you are reading?
Jamabandi. My lord, para 28.
Page 36, my lord.
Para 28 of the appellate order. Lordship got it?
Yes.
Shall I read it again, my lord? Para 28. Here, my lord, the other legal heirs of the Fatik Chandra Bora, they never raised any objection in this regard. And the DW1 also stated that in cross-examination also he deposed that this property is divided between the 2 brothers, the appellant and the respondent. Now they are denying to give him occupation as per the gifted made by the father. They have the deposition of the DW1 Jatin Chandra Bora, the elder brother of the appellant and respondent. He also himself said that the my lord, para 19 of the judgment, page number 15. Para 19 of the judgment. At page 32, my lord, page 32. Evidence of PW2 Jatin Chandra Bora is that he, defendant and plaintiff are all sons of Fatik Chandra Bora, and their father died in the year 1987, leaving him, his brother Hemchandra Bora, Devendranath Bora, and plaintiff, and 2 daughters, namely Damayanti and Bhuvaneshwari, and their mother Pratima, and their mother died in the year 1989. He deposed that after death of Fatik Chandra Bora, he all property devolved upon the 4 sons. After death of his wife, her share also devolved on them. And his father, late Fatik Chandra Bora, is the owner of the suit property. His father deposed that as per Exhibit 1, Fatik Chandra Bora gifted the suit property to the plaintiff.
What
and
is Exhibit 1?
Exhibit 1,
Jamabandi.
Jamabandi. The Hemchandra Bora gifted this property to plaintiff and Hemchandra Bora in 2 parts. It is a deposition by by the elder brother, PWD 2. PW2, the Jatin Chandra Bora, it is his statement in two parts. In cross, he stated that they are 4 brothers, 2 sisters, and all were got equal share on the father's property and the shoot land in their paternal property. He further stated that his father during his lifetime divided landed property to all children, and accordingly he got the properties of Chatial. Plaintiff and Hamchandra Bora got the old house. Plaintiff and also got a properties in Boru Bhugia and Jajoria, and all this division took place 30 years ago. So plaintiff
So regarding families arrangement, the evidence is oral evidence only. Okay.
So, my lord, since there is an oral evidence already, the appellate court, after going through the evidence and witnesses, deposition of the witnesses, as well as the credibility of the witnesses and factual inference, my lord, it found that there is an oral gift, and as per their deposition and cross-examination of the other brothers, it is already evident that the respondent is entitled for the half share of that property. And the Hamchandra Bora also, the appellant also could not deny it. He is not entitled. Now, if
Transfer of property. Transfer. Yes.
in para 19, in para 21 also, my lord, evidence of DW1 Hamchandra Bora is that his father, late Fatichandra Bora, had landed properties measuring 2 bigger 12 acres of the land with a 2-story wooden stencil building where he is now residing. He stated that his father never executed any deed of gift. The appellant himself admitted the father never executed any gift deed and delivered possession. And during lifetime of Fatichandra Bora, his 4 sons separated with their own consent. And after death of the Fatichandra Bora, the said separation was finally effected and plaintiff left for
Which para you are reading?
para 21 at page 33.
Yes.
So here also clearly the appellant himself admitted there is no any gift deed. This is the only verbal gift by the father, and he is
There cannot be a verbal gift. There can be a family arrangement.
Yes, my lord. So
So
father gifted them
whether the appellate court
correct decision, my lord.
took into consider,
Yes, my lord. On the basis of this deposition of these witnesses and the evidence of the documents, my lord. So appellate authority have correctly decided this matter, my lord. So, since there is family settlement, my lord, he is entitled under in the law of inheritance under Hindu Succession Act, my lord. So there is any dispute, no irregularity, no nothing.
so
is
it
wrong.
did not rely on the gift
My lord,
while allowing the suit of the plaintiff. It did not rely on the evidence regarding gift of the property.
no, my lord. The trial court never appreciated any evidence if this order has been passed on the basis of the statement made by the parties. None without going through the documentary evidence and nothing. Only said he could not pay, he failed to produce the gift deed, and that's why he is not entitled. My lord, in the appellate court, after examining the all relevant document and taking the witness, my lord, the credibility of the witnesses, my lord, and factual position of the cases, my lord, after examining the all things, my lord.
So your submission is that the impugned judgment is not perverse.
Not perverse, my lord.
Okay.
It is under, my lord, another thing, the supplementary question number 2, this is the self-record property, this is not ancestral property of Fatichandra Bora. And so far, non-general necessity is concerned, this issue was framed under issue number 4 before the trial court, where it is observed that joining of the necessary party is not necessary.
So in the appellate court also, observe the same thing, my lord. Joinder of the necessary party is not necessary. So, my lord, in this case, this subsequent question number 2 is not involved in this case to decide the RSA, my lord, appeal under section 100 of CPC. So, my lord, this is also not the correct issue involved in this case, my lord. And the issue number, subsequent question number 1 also not sustainable, not to be involved in this case, my lord, as per decision of the appellate court. Moreover, my lord, the appellant, if I am not entitled to get the share of the land as per the appellate court, my lord, the appellant on what basis is occupying this property himself? This question will arise, man. If I am trying to get my share, half share as per my father or a settlement. If I am not entitled, which was already admitted by him, the appellant and the DWD1 also, PWD2 also, they have admitted it is divided by the father between two brothers, the appellant and the respondent. Now they are challenging the appellate court's order, but they have not shown any perversity, irregularity, or unreasonability in the appellate court, in this appeal, in the RSA. So they have not raised any perversity made by this first appellate court. Here only if the issue number 4 for gender of the necessary party already decided by both the trial court and appellate court, which is concurrent decision. Now only reverse decision is under issue number 6, which was appellate court elaborately explained the detailed facts and evidence and credibility of the witnesses, factual position of the cases. After going through the evidence, it has passed this appellate order. So, my lord, since it is passed, but to further reappreciation of the fact, the evidence, it does not arrive before this honorable court, my lord, because they have not raised whatever the substantial question involved in this case, it is not sustainable, my lord. Substantial question number 2 is not at all sustainable, and 1 also not sustainable. It may be, it cannot be involved in this present case, my lord. So in this situation, my lord, if now another question will come, if I am not entitled to get the half share of this property as per the appellate court's order, my lord, then how the appellant is occupying without having any gift deed? How he occupied? If I don't have any gift deed, I am not entitled. It is not registered as if I. Then now the question is how then why he was filing another title suit at the 10K of 2011 before the trial court. The appellant filed himself to get the share of the land. So both party knows this property is gifted by father, but during the family settlement and distributed between the two brothers. Then other portion of the father given to the respondent. This is a separate issue, but this suit property is given by father between the distributed between the two brothers. So in such a situation, the half share of this property.
So is it your submission, though there was no formal gift deed?
Yes, my lord.
But it was a family arrangement made
Yes.
by the father
Yes.
between two sons.
Yes, my lord. It is already admitted.
Okay. Okay.
That's not the pleaded case, their case, my lord. Their case is that, my lord, there is a gift, my lord. Now, the whole story, my lord, they're relying, my lord, it's a story, my lord, which is not pleaded
This
case.
story is not
My lord, whatever maybe,
not
my lord,
made by
it's
the
these are-
respondent.
it's civil suit, my
After
lord.
going through the all document evidence, witness
Court will go through the
of the
plain and
evidence,
obvious.
witnesses, my lord, appellate court observed. It is not my observation. It is appellate court's observation. So appellate
No,
court-
his submission is that the appellate court went beyond your pleadings.
no, my lord, not beyond.
Clearly, my lord, there is nothing in the pleading regarding family settlement
My
at
lord,
all, my lord.
But in
Not a
the
single word.
already, my lord, in
The entire case is there, my lord, that's
DW1 and PW2 already submitted in their cross-examination and evidence on affidavit. They said it is distributed by my father between two brothers, this Hemchandra Bora and Kanikanta Bora. This is their deposition in cross-examination.
Heard. Mr. P. Sundhi, learned counsel for the appellant. Also admits U. Chakravarti,
For the respondent.
learned counsel for the respondent. Hearing concluded, judgment reserved.
Much of.
Assembly. This is my humble prayer. God will please to uphold the justice of the appellate court.
That is your not prayer, that is your submission.
Sorry. This is my submission, my lord. Oblige your lordship.
Nothing else. Yes,
6 minutes.
item number? Yes, what is this?
No, no, see, my lord. There is only one question, my lord, of substance question of law. Lordship may just comment. Because this is judgment of reversal. Whether the first appellate court was justified. You know,
On which date the substantial question was?
yes, 2012 by lord.
11/6/2013 order.
11/6.
Yes,
Well, whether the first appellate court was justified in declaring the suit of the plaintiff by holding that the plaintiff has completed 97th work by so and so, ignoring the stipulation in the work order, the 5995, exhibit 5, relating to the period for completion of the work. In this matter, my lord, the work order was issued on 15/9/95. The 59.
no, what is this? Is it a substantial question?
Yes, my lord, because by that, my lord, the time is fixed. That is why. That is why the time is fixed by the work order.
No, it revolves around question of perversity,
House.
perversity.
Perversity.
That it
Yes.
ignored.
My lord, power city, okay, but that is why, my lord, that is why it is, my lord, ignoring the stipulation. That is a power city, my lord.
Okay. So therefore, whether the judgment was perverse.
My lord. My lord, your lordship will see, my lord, the work order at 59, which is exhibit 1, my lord.
Page,
Page, my lord, in the trial court, my lord.
you have a copy of that? No,
Yes,
what,
I have it.
no, what are the facts in brief?
Facts in brief is it, my lord, on 15/9, this work was issued for completion of the same within 1 month, 6 days from the 3rd day of the order.
15/9,
90
15/9/96,
95.
work order was issued.
And it was also mentioned that the agreement will be executed within 7 days. But these few stipulations are there. I'm just giving a copy of the order, ma'am.
That order copy is not there in the record.
In the trial court record is there. Just your lordship.
It is exhibited.
Yes, exhibit one. Did you? Yeah.
What is this? This is the,
Work order.
okay.
My lord. Your tender number so and so. So and so. By part of the same so and so. You are requested to attend this office in person between 2 p.m. to 3 p.m. on any working day within with 3 rupees 50 paisa value of non-judicial stamp paper and legally typed strictly in accordance with the draft and close herein to sign and complete the format agreement in presence of the undersigned within 7 days from the date of issue of this letter. And please note that time of 1 month, 6 days for carrying out the work is that the tender shall be reckoned from 3rd day of from the date of order. So, my lord, if your lordship were for my lord, that it will be from the 18th, my lord, he has to start the work, and within, my lord, 22nd, he has to execute the agreement.
No, what is the submission?
But my submission is this, my lord, if your lordship, my lord, the time for completion of the work is, my lord,
The work order was issued on 15/9.
15/9, my lord, so it will be, my lord, 1 month, 6 days. So it will be 28th of, my lord, October 1995.
Within 28th October, the work has to be.
No, 24th and 24th October. 24th of October, 20. '95. 24, 10, 95. This work is to be completed.
Okay.
Then he did not turn up. On 5/10, we have issued a letter to him to execute the agreement and to complete the work immediately by starting the work. So even after, my lord, issuance of the work order, 20 days elapsed, he did not appear before the authority for execution of the agreement. Then after issuance of the, in the letter, my lord, we have said that we shall terminate the agreement if you cannot complete the work. Then the respondent, my lord, executed the agreement on 6/10/95. These are admitted facts, my lord.
Yes, thereafter.
Thereafter, my lord, he said that he started the work from 8/10/95. And by 11/11/95, he said that he has completed about 95%. Now, your losses were considered a trial court judgment, my lord, at this stage, my lord. Yeah.
Page number,
My lord, page 62, my lord,
page,
page 62. My lord, I may skip over, my lord, with these 4 paragraphs. Then paragraph 5, my lord, at page 64, because that is only up to issuance of the work order, 5995. Paragraph 5, you also got it, at page 64.
yes,
That after a work order annexure 1 was issued, the defendant number 4 issued a letter memo number so and so 510 95 60 95 requesting a plaintiff to enter into a formal agreement within 7 days of issue of the letter. The aforesaid letter contains several statements of cautious warning that the corporation might cancel the work order and forfeit earnest money unless the works were completed, like whether the agreement was signed or not. The letter further warned that plaintiff may be debarred from getting any further contract. As the letter dated 1695 had serious implications on the plaintiff, he immediately met the defendant number 4 in his office and wanted to know the reasons for writing the letter. The defendant number 4 stated that the plaintiff that the letter was issued to impress upon the plaintiff to expedite the contract work. However, the plaintiff got signed the agreement on 6/10/95 and started works with effect from 8/10/95. Plaintiff in right earnest proceeded with the contract work. He made huge investment and purchased required materials and thus proceeded with the work. When the contract work was at the verge of completion on 11/11/95, the plaintiff was shocked to receive a letter dated 2/3/11/95 issued by the executing defendant corporation. The aforesaid letter allegation was made against the plaintiff that he had not earned to start the work till that. While making the allegation, the plaintiff has not earned to start the work till that, and defendant number 4 gave a show cause to the plaintiff as to why action so and so of the contract agreement shall not be taken against him on account of breach of contract on his part. The plaintiff was further warned that if no cause is shown within the stipulated period or cause shown by him is not found satisfactory, defendant number 4 shall be forced to contemplate rescinding the contract under clause number 3 of the contract agreement. As stated above, the said letter so and so was received by the plaintiff on 11/11/95, and therefore the question of plaintiff giving reply so-called notice within the so-called stipulation of 7 days cannot arise. Moreover, it is pertinent to mention here that the said so-called notice did not specify as to from which that stipulated period of 7 days would start. Before the receipt of the said letter, plaintiff wrote a letter dated 10/11/95 by defendant number 4. The letter of the plaintiff contained progress report of the works. In the said letter, it was stated that plaintiff has already completely executed 97% of work, keeping up the urgency reflected in the letter that 6/10/95. In the letter, assured by the plaintiff that the balance work will be completed in short time. The plaintiff also requested a said letter that it will be highly appreciable if defendant number 4 makes the said arrangement for drawing up the plaintiff's bill for the work done at the earliest. The said letter was sent to the office of the corporation at the Sikona registered post on 10/11/95, and on the same day, plaintiff also handed over a copy of the said letter personally to the said office. That immediately after writing of the said letter, so and so plaintiff received letter dated so and so of the defendant number 4, being surprised and shocked. The plaintiff immediately thereafter on 30/11/95 to the defendant. The said letter of the plaintiff gave reference to the letter that 10/11/95 and reiterated that he has already completed 97% of the work, contract work. It was stated that by the plaintiff that contract work was completed by him by 8/11/95. It also stated that the plaintiff, that after execution of the said work in the month of November, most hard standing work like bricks, beds, etc. were almost completed. It was also informed that the said letter, the balance work of 3% was not executed as per instruction. The defendant number 4 himself. However, it was assured that the plaintiff that he undertakes to complete the work as and when directed by defendant number 4. The said letter, the plaintiff has also repeated request, had met the what? No, this is, I'm plain one. I'm sorry. I'm sorry, my lord. I'm sorry, my lord.
This is not.
I'm sorry, my lord. Title should be page 103. No?
In my copy, it starts from page 8.
Huh?
The title should.
Oh, page 8. Yes, I'm sorry. Page 8. I'm sorry, my lord. The case of the plaintiff in brief is the plaintiff was allotted the contract work by the defendant and the work order is issued on so and so. As for the work order, contract is to be completed within 1 month, 6 days, which will start from the 3rd day of date of order. Thereafter, the defendant for issued the letter dated 5/10/95, 6/10/95, requesting the plaintiff to enter into a formal agreement within 7 days. The plaintiff signed the agreement as required on 6/10/95 and started the work with effect from 8/10/95. He made huge investment and purchased required materials and thus proceeded to the work. Time for completion was, my lord, that same. That is, I have said, my lord, 24. 24/10. Thus, he proceeded to work. Surprisingly enough, the work was on the verge of completion on 11, and the plaintiff received a letter that 3/11/95 issued by the executive engineer of the defendant corporation, wherein he alleged that the plaintiff has not started the work till date. He has not started the work till date, madam. That is our case. And so cause was issued to the plaintiff as in why the contract agreement being not taken against him, account breach of contract on his part. It was also mentioned that if so cause was not given within the stipulated period, if so cause was found to be not satisfactory, then the defendant would rescind the contract. It was claimed that as the letter received by the plaintiff was only on 11/11/95, so the question of reply to the so cause within the stipulated period cannot arise. So stated before the receipt of the said letter, the plaintiff on 10/11/95 sent a letter to the defendant stating about the progress of the work and informed that 97% work was done. Ever that the balance work was completed within a period of short time. He also paid for making necessary arrangement for drawing the dentist bill for the work done so far. After receipt of the letter dated 2/3/11/95, defendant number 4, the plaintiff again wrote a letter on 13/11/95 to defendant number 4 and reiterated that he has completed 97% of the contract work. It also stated that after execution of the said work in the month of November, hard hitting work like brick beds, etc., were also almost completed. And assurance was given for completion of the remaining work within short time. It also informed that he received the so-called notice dated 11/11/95, but the plaintiff received the same on 18/11/95. Another letter dated so and so on 17/11/95 by the defendant number 4 rescinded the contract work and also forfeit the arrest money. Well, this is the the plaintiff by defense dated again informed the defendants regarding completion of the 90% of the work. Thereafter, on 16/11/95, a telegram was issued to the defendant number 4, directing plaintiff to remain present on 18/11/95 for taking measurement of the dumper bricks collected at the work site in presence of the technical staff. On 25/11, another letter was received by the plaintiff on 20/11/95, whereby defendant brought allegation that the plaintiff claimed regarding completion of 90% of work is totally false, and he was threatened to be blacklisted. It was severe on the part of the plaintiff that the above so-called notice was issued without affording any explanation and without certain whether the plaintiff has received the so-called notice or not. The contract was rescinded by the defendant number 4 without any authority. It was stated by the father that during the earth filling over the so-and-so worksite, technical staff of the defendant were present each day in terms of clause 16, and verbal notice was given regarding starting of the work about and about this there was mentioned in the plaintiff's letter dated 10/11/95. It is submitted that the defendant never conducted any inquiry on the spot to ascertain non-execution of the contract work as alleged by the defendant, nor the so-called notice of the defendant and rescinding the contract letter that defendant so that any inquiry was held before passing of the order. It is further submitted that defendant number 4 wrongly invoked the power and illegally issued the so-called notice and rescission of the order without fulfilling the precondition prescribed in clause 3A, B, C of the contract agreement, and this is illegal and mala fide. He submitted that plaintiff informed the defendant number 4 on 10/11/95 about the completion 97% of the work, and in spite of the receipt of the said letter on 14/11/95, rescinded the contract work. After delivery of the said letter, the plaintiff with full knowledge of the defendant number 4 proceeded with the completion of balance work of 3% and almost completed the work before issue of the so-called notice. Hence, the present suit for declaring that the rescission is illegal, void, and for declaring that the work order address so and so and agreement address so and so is still subsisting, and the defendant are bound to get balance work, if any, done by the plaintiff for decree of rupees 2 lakh so and so for contract work done by the plaintiff with interest for decree of refund of earnest money and permanent injunction. The defendant filed written statement registering the claim of the plaintiff, said the suit is not maintainable and altered by the law of limitation, denying the allegation and claim of the plaintiff. At admitting the issuance of the contract work by the defendant on 15/9/95 to the plaintiff, he submitted that though plaintiff was asked to start the work immediately after receipt of the work order and to sign the formal agreement within 7 days from the date of issue of the work order, yet plaintiff, in spite of repeated requests, did not enter into the agreement within the prescribed time limit, and ultimately, after a strong issue of the letter by the defendant, entered into an agreement on 6/10/95. They submitted that plaintiff also did not start the work even after entering into the formal agreement on 6/10/95. And thereafter, the defendant number 4 verbally requested on several occasions to start the contract work. But the plaintiff did
What
not-
was the work, nature of work?
Well, the filling of the earth and bricks, my lord. Yes, civil work. Construction of a ring bound and earth filling.
Yes.
So start the contract work, but plaintiff did not pay any heed to the request. So getting no alternative, defendant number 4 issued a so-called notice on 2/11/95 as per clause so and so of the agreement. In the said notice, plaintiff was asked so-called within 7 days, otherwise to rescind the contract work. Prior to this letter, the defendant also issued letter at 5/10/95 asking the plaintiff to execute the formal agreement and to start work within 3 days. He was sufficiently impressed regarding urgency of the drilling site for a person or rig. He also mentioned in the said letter that if he does not start the work, then the defendant number 4 will take necessary action. As the plaintiff did not reply to so-called notice dated 2/11/95, hence the defendant had no alternative but to cancel the work order and to forfeit the earnest money as per the agreement, as the drilling site was urgently needed to be ready for installation of drilling rig. He submitted the plaintiff by letter dated 10/11/95 and 13/11/95 falsely claimed the completion of the work site, work up to 97%, and defendant number 4, prior to receipt of said letter, issued the cancellation order for non-supply of the so-called notice, non-reply of the so-called notice, stating the plaintiff claim as false, stating that the cancellation order was illegal, was made legally, and defendant paid for dismissal of two. What are the issues you are framed, my lord? Now, my lord, 1, 2, 3, I am speaking over, my lord. The 4 and 5, my lord, that your losses may see, my lord. That is the important issue, my lord, which are at page 21. Jointly discussed.
Yes.
At page 21, last para 9, issue number 4 and 5. It appears that exhibit 1 is a work order that is so-and-so, that immediately within 7 days of the work order, formal agreement which was executed by the plaintiff. But the plaintiff did not execute the such agreement within the period of 7 days. The said work order, exhibit 1, shows that time for contract is 1 month, 6 days. will start from third day of the order. So from the perusal of Exhibit 1, it appears that within 24/10/95, the work order is to be completed. Exhibit 4 is a letter that 5/10/95 issued by the defendant number 4 shows that the plaintiff did not enter into an agreement till that day and also did not start the work till issuance of the said letter. And as such, the defendant number 4 issued the said letter, directing the plaintiff to execute the work as it was urgent, otherwise threatened to cancel the work and forfeiture of the earnest money. The plaintiff letter 10/11/95, exhibit 5, 2 and 5, itself shows that he claimed to be completion of 97% of work and not the whole work of the contract. The period of the contract already discussed as up to 4/10/95. There is nothing on the record that time for the contract was extended by the defendant. They have not paid also, madam. The plaintiff claimed that though he did 97% of the work, informed the matter to defendant number 4 by letter 10/11/95 and 13/11/95, exhibit 2 and 5. The defendant 4 cancelled the work order. Defendant claimed that as per the, on the other hand, that the plaintiff, though was supposed to start the work in the third day of the month of September, third week of the month of September, yet he did not start the work in spite of repeated requests to start the work. Even after entering into a formal agreement on 6/10/95, failed to execute the work. Exhibit 4, that is letter 5/10/95, the plaintiff's own document shows that plaintiff did not execute the work till 5/10/95 in spite of work order at 15/5/95. The plaintiff did not agitate to contest exhibit 4 in any way. Thereafter, the defendant number 4 issued letter dated 2/11/95, exhibit 6, alleging non-starting of the work and threatened to cancel the work order and forfeiture of the earnest money if reply the show cause is not given within 7 days. The plaintiff claimed that he received the show cause notice, exhibit 6 on 11/11/95, and prior to receipt of the letter, the show cause, he issued letter dated 10/11/95. Exhibit 2 stating about the completion of 97% of the work. In spite of the claim, the plaintiff that he could not file the show cause as per letter 2/11/95, exhibit 5 the defendant within 1 week as he received the letter on 10/11/95. So it appears the plaintiff, though admitted the receipt of the letter of the show cause at 2/11/95 of the defendant, yet he claimed that he received it only 10/11/95, as the plaintiff was taking a specific plea regarding the receipt of the letter 2/11/95 on 11/11/95. Hence, it was burden on the plaintiff to prove this said fact. He could not be called for AD card from the defendant or could have called for the postal receipt from the post office to prove the said fact, but he failed to prove the same. As the plaintiff failed to show cause as stipulated in the letter dated 2/11/95 within time, hence on 13/11/95, the defendant number 4 issued exhibit 7 rescinding the work of the plaintiff. As he mentioned that the plaintiff under what circumstance under clause 3A, B, C, the contract agreement is rescinded. As per the clause 3 mentioned the plain, appears that breach of term of the conditions of the contract, terms and delay in execution of the work are also some of the conditions under which contract can be terminated. It also appears that after issuance of the prior notice, the defendant can terminate the contract on the ground mentioned in clause 3 of the contract agreement. So it appears that after issuance of the notice dated 2/11/95, the defendant issued the cancellation order as no reply of the show cause was given by the defendant within the period mentioned in the notice. The plaintiff of the other hand claimed that prior receipt of the notice, such notice on 10/11/95 by the exhibit 2 10/11/95 informed the defendant completion of the 97% contract work. Surprisingly enough, plaintiff could not show anything that earlier to these 2 letters, he informed the defendant number 4 about completion of the contract work or starting of the work within the stipulated period of contract or immediately after expiry of the stipulated period of contract. Now, this is interesting, my lord. On 2/11, we have issued the letter, and he, this prior letter, my lord, on 6th issued, he received on 6th itself, and he executed the agreement on 6th. And this letter, he has said that he received on 10/11, and 10/11 issued another letter that he has completed 97% of the work. It's interesting, my lord. Only after issuance of the so-called notice, he came with a belated plea that he completed 97% work. As per para 18 of the plaint, it appears that clause 16 and 24 is in that form of contract work. Before commencing the work, levels for sanction measurement has to be taken, and all works shall be executed under the direction and subsequent to approval of all the respects of the engineering charge, who shall be entitled to direct at what point or points they are to be commenced and from time to time carried on. Moreover, 7 days notice in writing to the engineer should be given covering any work in order that he stem may be measured. So it appears that as per the above clauses, the plaintiff had to issue notice regarding starting of the work, and on approval of the direction of the engineering charge, the work can be done. If the plaintiff actually did the work as alleged, he could have produced some of the documentary evidence regarding notifying the authority concerned about starting of the work as soon as that commenced the work. But as if he has failed to submit the documents in this regard, he has also failed to call for the documents from the defendant's side to show that their staff were present at the time of execution of the work, as he claimed in paragraph 19 of the plaint. He also failed to show any document that immediately after stipulated period of contract, he informed the defendant about the completion of the work of 97% of the contract work. He also failed to show any document that he submitted the bills regarding the art filling of the work done by him in the project site. From all above facts, it appears that the plaintiff claim regarding execution of any work in the drilling site is not tenable. He also failed to show cause the defendant's letter dated 2/11/95 within time. Accordingly, as the rescinding letter, as per terms of the contract agreement, the defendant of court issued the rescinding letter. So there is no illegality done by the defendant issuing the cancellation letter and also for forfeiting the earnest money. It also appears that already the terms of the contract has expired on 24/11/95. Hence, no declaration can be given and the contract is still subsisting. In view of the discussion, issue number 4 and 5 is decided in the. Hello.
How the first appellate court
Yes,
differed?
madam. Yes, I'm. Madam, that is. It's 34. Take the fact. 26.
Issue
Page
number,
26. Page 26.
page 34 is the
20,
issue number
Issue
4
number
and
four.
5.
Yes. Yes. Page 34 is number 3. It appears that the defendants invited tenders for executing civil work at Baskanti drill site, which is known as business so and so. Civil works related to construction of ring, bund, and art filling of the drill site area. The estimated cost was 5,80,000 so and so, and plaintiff submitted the tender along with other contractors, quoting a rate of rupees 2,31,000, which was the lowest, for which was allotted the said work as exhibit 1 work order, dated 15/9/95. The work order, urgent in nature and time, allowed the plaintiff 1 month 60. In the aforesaid order, the plaintiff was asked to start the work immediately after receipt of the work order and to sign the formal agreement within 7 days from the date of issue of the order. So thereafter, repeated request by the plaintiff entered into agreement on 6/10/95, but failed to start the work. Then the defendant requested him verbally to start the work, but the plaintiff did not pay any heed, for which the defendant issued a shock notice dated 2/11/95, giving him 7 days time. But the plaintiff failed to submit shock cause within the stipulated period. Then, as contemplated in clause 3 of the agreement, the defendant number 4 by the exhibit 4 dated 13/11/95 rescind the contract and forfeit the earnest money to the corporation. He also issued one telegram to the plaintiff requesting him to remain present on 18/11/95 at 11 AM for taking measurement of the Jama bricks beds collected by him at the site. But the evidence of the plaintiff reveals that entering into agreement, the defendant with the defendant on 6/10/95. He started the work on 8/10/95. And he completed the contract work by the letter 10/10/95, Exhibit 2, 10/11/95, it should be 10/11. Exhibit 2, he informed the defendant about in response to letter 6/10/95 about the progress of the work and assuring that he would complete the remaining work within short time. He also requested the defendant to make necessary amendment for payment of up to the bill so and so. My lord, normally what happens, my lord, in the contract works, my lord, the bills are time to time, my lord, submitted, my lord, running bills. But here, no, nothing, my lord. He also requested the defendant to make necessary amendment for payment of up to the bill. His evidence also reveals that in spite of his received so-called notice from the defendant on 11/95 and 30/11, he sent another letter to the defendant of 4 informing of the progress of the work and other to complete the outer work. But despite this, the defendant of 4 rescinds the contract on 13/11/95. The plaintiff has exhibited series of photographs with negative in Exhibit 2 and to 21 and Exhibit 21 to 527 challans supplying art.
We will continue after lunch. After.
That
Yes.
I am placing at page 36, my lord,
Yes.
para 12. Mr. B.K. Parker, learned counsel for the defendant submitted that Exhibit 8 and 21 to 527 are not admissible evidence and challans bear no signature of the defendant, which according to him prepared by the plaintiff himself, and as such the claim of the plaintiff that he completed 97% of the work hold no water. Mr. Purkayastha further submitted that no document relating to payment of land compensation or forest royalty, well, forest royalty is necessary, my lord, now were not produced. The RC of the vehicle used carrying our log books, payment register has also not been produced for conclusion. Mr. Purkayastha further submitted that the photographs are also not admissible. The plaintiff has failed to complete the work in time and also failed to furnish so-called reply. As such, the defendant number 4 rescinded the work order on 13/11/95. In view of section 55 of the law of contract, the burden to prove the completion of 97% of works is upon the plaintiff, but he failed to discharge the same. Mr. Purkayastha further submitted that there is no infirmity in finding of the learned trial court and there is no ground for interference. Where Mr. D.K. Dev, learned counsel for the appellant, submitted that he not open to object the admissibility of documents which were exhibited in the learned trial court without any objection from such party, and once document is properly admitted, the contents of the same is admitted in evidence. My lord, this is wrong, my lord. Contents never admitted, my lord. Though the contents may not be conclusive evidence. Mr. Dev referred to case law so and so in support of his submission. Mr. Dev also submitted that despite learned trial court failed to take into account those documents, Mr. Dev further submitted that plaintiff could not submit any show cause as the letter has been received at the 11th hour, and the same also not disclosed from which that period of 7 days has to be reckoned. Which Mr. Dev further submitted that the defendant failed to appear in the witness box to state his case and failed to offer himself for cross-examination to test the veracity of the case, and as such adverse inference can be drawn against the defendant's side. Mr. Dev referred another case law, Vidyadhar appellant so-and-so versus so-and-so, in support of submission that further submitted that defendant has not produced any card to prove the receipt of so-called notice by the plaintiff, and it is rescinding the contract without holding any inquiry, and as such, the order of rescinding the contract is arbitrary, illegal, void, and has been violating the principle of transparency. We considered the rival submission of the learned advocate for both the parties, and we have gone through the case laws referred to by Dev, counsel of the appellant versus so-and-so, and held that it not open to a party to object the admissibility of documents which were marked as exhibit without any objection from such party, and once the document is properly admitted, contents of the same are also admitted in evidence, though those contents may not be conclusive in the case so-and-so in hand, as also the photographs and one chart of challans which were marked as exhibit 8 and exhibit 11 and 21 to 527 before the trial court without any objection. As such, it is not open to a defendant respondent to raise any objection about the admissibility of the same. And unfortunately, the learned trial court neither discussed nor made any reference about the exhibit 8, 11, and 21 to 527 of the judgment. Besides, there is no evidence to rebut the same. The defendants neither appeared in the witness box to state their case on oath, nor it offered themselves to cross-examination by the other side. And such presumption would arise in case of set out by them is not correct. Mr. Dikadir, the Honorable Counsel for the appellant, has rightly pointed out in his argument that case law Vidyadhar fully endorsed the view. Apparently, no inquiry conducted by the defendant side about a claim of completion of 97% of the work of the plaintiff. My lord, in this regard, I must submit, my lord, that they were given time, my lord, to appear there for joint inspection measurement. The letter that is so and so for rescinding contract work bears no indication that effect. There is nothing on record to show that plaintiff has received so-called letter in time. The learned court below observed that the judgment of the plaintiff could have called for the AD to prove that he received the so-called notice letter so and so, or could have called for a postal document to prove the statement, but he failed to prove the same. But the learned trial court failed to take into consideration the AD card was in possession of the defendant, and that the defendant side could not have produced the same to rebut the claim of the plaintiff, but it has not produced the same. DKD learned counsel for the appellant regarding referring the one case law so and so, 68 Supreme Court, submitted that the party in possession of the best evidence who should throw light on the issue controversy failed to produce the same, then adverse inference can be drawn against such party. We have gone through the case law and we find that submission of the learned counsel for the appellant is well founded and both in law in fact. We find that submission of DKD got sufficient force. There is no evidence on record to rebut the version of the plaintiff that he has completed 97% of the contract work. Exhibit 2 and 3, the letter of the plaintiff, and exhibit 8, 11, and 21 to 527 leads assurance to the claim so made by the plaintiff. Defendant failed to conduct any inquiry to rescind the contract and work and letter that so and so of the defendant bears no such indication. There is also no evidence to show that plaintiff has received so-called notice letter in time. As such, he could not submit a reply. It also emerges in the contract work that has been rescinded without hearing the plaintiff and giving him opportunity of explaining the circumstances to why he could not complete the work as admitted that he has done some work. Thus, the mandate of clause so and so, the contract book standard form, has not been complied with the letter and spirit. As such, it has been made arbitrarily in contravention of the said clause so and so. That being the position, the finding of the learned court below erroneous and the same requires interference in the court. Accordingly, we set aside decision. Well, this is the matter. Then accordingly, decree has been passed, my lord.
Now the decree has been stayed.
Should be decreed.
Now in this second appeal, any stay has been granted.
Stable payment of 50%.
You have paid 50%.
Yes. Hello, first thing here, a telegram was issued to him that your lordship has seen earlier for joint measurement. He has not appeared there. My lord, if anything, any work was done. And in fact, there is no work at all, my lord, actually. And so far the documents are concerned, my lord, I shall place reliance on 3 judgments of the Supreme Court. First, my lord, yes, take it. First one is, my lord, 71 Supreme Court 1865. Just give me.
No, the question of law before this court is a different question.
Yes.
Whether the first appellate court failed to consider the stipulation in the work order.
My lord, that is correct.
That is
what I am saying, yes. That is what I am saying. Because that work is to be completed on or before 24/10/95, my lord. And no, there is no application for extension of the time also. So there could not have been anything there, my lord. Because he did not come up for 20 days, he was sitting mum, my lord. Although within 7 days, he has to execute a work order. And he admittedly, he said that on 6th, October, he appeared before them for work, signing the work order after receiving the letter dated 6/10. On the same day he received. Then from 8/10, he started the work as per him, my lord.
No. Whether the court, first appellate court took into consideration that it believed that work was done.
He only relied on the documents submitted before him. Challans, from where challans came, my lord, there are no signature of the defendant, because in every challan, my lord, the receipt must be given. When they submit, my lord, the same, the receipt is given. Nothing is there, my lord. It is prepared by him behind the way.
What is exhibit 2? Exhibit 2 and exhibit 3.
Exhibit 2 is my intimation to
yes.
the ONGC that I have completed 97%.
My lord, 10/11/95.
And 1190. Exhibit 3.
He is the under letter giving reference to the letter dated 10/11/95, 13/11. And exhibit 4 is the letter of cancellation.
Exhibit 8.
My lord,
Exhibit 8.
Eight are the photographs, by which we have shown that the works are complete.
8, 11 and 21.
8, 11, 21. 11 are the challans and draft number, by which we showed that this earth and soil that were brought for execution of the ring band. And 21 to 527 are the challans, which was for showing that this earth was supplied and this low-lying area that was filled up.
These documents mainly trial court, the first appellate court relied upon.
yes, these are the documents. And these are one-sided mallet documents because there is no signature of the defendant. Because when something is supplied, the defendant give the receipt mallet. And moreover,
No, why defendant will give the receipt? Suppose he has to fill up earth.
yes,
Challan is for purchasing
mallet,
earth.
first when this certificate is to be given mallet for the bill, that is compulsory mallet under the law. First when the certificate. Because royalty is applicable. Without that, my lord, there are many judgments of our house. And measurement has also not been, my lord, they have not appeared before the death, my lord, for taking the measurement. Although telegram has been issued to them. No logbooks, my lord, no vehicle number carrying the earth. No payment register, nothing is there, my lord, except the challans, my lord. Anybody can manufacture the challans.
No, otherwise how it would have been proved that the work is done
My
completely?
lord, he should have appeared, my lord, at the time of joint measurement. We issued the telegram for the measurement, whatever work is done. We have found, my lord, virtually no work has been done.
So one thing your lordship will find, this telegram that was issued on 16/11/1995, whereas the work order was rescinded on 13/11/1995.
Yes,
So after rescinding the work order, how they are sending me a telegram on 16/11 to be present on 18/11 for taking measurement of the Jama pit?
that's not the matter.
When they've al-
Okay.
No royalty payment certificate, no logbook.
What is this judgment?
No. These are judgments for these documents are virtually, that is why I am submitting. 71, my lord, paragraph 15 only, my lord.
Para 15.
15, only one paragraph.
What it says?
The plaintiff wanted to rely on exhibits 8, 12, and 13, that day book and ledger respectively. The plaintiff did not produce these books, did not prove these books. There is no reference to these books in the judgments. The mere marking of the exhibit does not dispense with the proof of the documents. Marking of the exhibit, they have marked on the exhibit. It's a common place to say that negative cannot be proved. The proof by the plaintiff books of account become important because the plaintiff's accounts were impeached and falsified by the defendant case larger payment than those admitted by the plaintiffs. Well, this is the only matter thing. The next case is my lord 2010 4 SCC 491. Here, my lord, I am relying on 3 paragraphs 25 to 27 and 31. At page, my lord, 496. You also got it, my lord?
Yes.
Paragraph 25. We have the firm opinion that mere admission of document in evidence does not amount to its proof. In other words, mere marking of exhibit on the document does not dispense with the proof which is required to be done in accordance with law. As has been mentioned here above, despite perusal of the record, we have not been able to come to know as to under what circumstances the respondent plaintiff has admitted the two documents. Even otherwise, his admission of the documents cannot carry the case of the appellant as any further and must be reduced to the respondent. It was the duty of the appellant to probe the documents, exhibit A1 to 10, in accordance with law. Filing of the inquiry report or evidence adduced during the domestic inquiry could not partake the character of admissible evidence in the court of law. The documentary evidence was also required to be probed by the appellant in accordance with the provisions of Evidence Act, which they have failed to do. 1031. Under the law of evidence, it is necessary the contents of the documents are required to be probed either by primary or secondary evidence. As most of the documents amount to admission of the contents, but not its truth. Documents having not been produced and marked as required under the Evidence Act cannot be relied upon by the court. Contents of documents cannot be probed by merely filing in the court.
How contents are to be proved?
Well, this is, well, they have to probe it. Well, the contents are to be probed. Well,
How?
here by showing that these are vehicles by which we have carried. These are the first royalty certificates, because for payment, my lord, nowadays also first royalty certificate is produced, my lord. First royalty is compulsory, my lord. Royalty, they have to pay royalty, my lord. There is no vehicle number, nothing over this all, by which they have carried. Mere marking of the documents are not the proof. And moreover, my lord, at site also they have not gone there for joint measurement. Now, next case is 2011 4 SCC 240. Paragraph 11 to 17, my lord.
Yes.
My lord, in view of the pleading, the respondents actually denied the execution of power of attorney in favor of R. Viswanathan. Defendant number 2 in the suit, the main issue could be as to whether power of attorney has been executed by the respondent in favor of R. Viswanathan, enabling him to alienate the suit property. Anyway, there was such power of attorney, whether the same has been proved in accordance with law. The provision of section 65 of the 1872 Act provides for permitting the party to adduce secondary evidence. However, such a course is subject to a large number of limitations. In case where the original documents are not produced at any time, nor any factual foundation has been laid for giving secondary evidence, it is not permissible for the court to allow a party to adduce secondary evidence. The secondary evidence relating to the contents of documents is inadmissible until non-production of the original as the account report. So as to bring it within the one or the other is provided in the further section. The secondary evidence must be authenticated by the foundational evidence and the
This judgment you are relying
Yes.
to show that challans are not
Yes, not,
be-
not all.
believable. Okay.
And the appellate court has not considered the, my lord, first thing, my lord, that what is the work order, my lord. That also not considered. The learned trial court has considered the same. my lord. Because he admittedly, my lord, he said that he started the work on 8/10, whereas 24/10 is the last date for completion of the work. Only after receipt of our letter, he came for execution of the agreement. But it was duty to come within 7 days to execute the agreement. He has not done it.
Yes.
This, Muhammad Sir.
Lordship, first of all, without going into the assuming that I have not completed this work, without not going into all these facts, I would like to rely on the on section 100(3) of the CP.
Yes.
I'll read from 100. Save as otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie to the High Court from a every degree passed in appeal by any court to the High Court. Now, whether this can be considered as a substantial question of law is a purely substantial question of fact. There's substantial facts. These are completely facts. These are not law at all. And the apex court has many times the apex court has said that the first appellate court is the last court on facts. The second appellate court can only interfere when there involves a substantial question of law, not any further. Of course, if there is a perversity. Now, where is the perversity? I have not found. And regarding that decision, I'd like to submit to your lordship. Was passed in the year 2021. Malana Goda versus Ningana Goda.
What is the citation?
Reference is 2021 SC 188. SC 188. I like para 10. Para 10. I'll read out. The first appellate court is the final court on facts. It has been repeatedly held by this court that the judgment of the first appellate court should not be interfered with by the High Court in exercise of its jurisdiction under section 100 of the CPC, unless there is a substantial question of law. The High Court committed an error in setting aside the judgment of the first appellate court and finding fault with the final decree by taking a different view on factual findings recorded by the first appellate court. So similarly, in this case also, there is a purely a factual finding. And where is the perversity that could not be shown by my learned senior. So therefore, this is not a substantial question of law.
So unless there is a perversity.
Unless there is a perversity.
This court cannot come to a different finding from that of the first appellate court.
Yes, yes. Because the finding of facts is limited to the first appellate court.
Okay.
So here also, the finding of the first appellate court is clear At page 38, I'll read again. These are the findings. I'll start from page 37 itself, 14, paragraph 14. We considered the rival submission of the learned advocates of both the parties. We have gone through the case laws referred by Mr. D.K. Dev, the learned counsel for the appellant. In P.C. Purushottam versus so-and-so, Honorable Supreme Court held that it is not open to a party to object to the admissibility of documents which are marked as exhibits without any objection from such party. And once a document is properly admitted, the contents of the document are also admitted in evidence, though those contents may not be conclusive evidence. In the case in hand, also the photographs and one chart and the challans were marked as exhibit 8, 11, 21 to 527 before the learned trial court without any objection. Now, your lordship will find in regard to these exhibits 8, 11 and 21 to 527, there is no reference of these exhibits made by the trial court. Nowhere your lordship will find in that judgment. So accordingly, these exhibits have been discussed by the first appellate court hearing. And as such, it is not open to the defendant respondents to raise objection about the admissibility of the same. Unfortunately, the learned trial court has neither discussed nor made any reference about the exhibits 8, 11 and exhibit number 21 to 527 in its judgment. Besides, there is no evidence to rebut the same. This is also important that this ONGC, they have only filed a WS. Thereafter, they do not appear. There is not even a no oral evidence on record to prove any document. Now, how I have produced these documents saying that these are the photos, these are the challans, and these are the soil and everything that I have completed the work.
What were the questions put during cross-examinations?
I don't have the cross-examination, means they did not appear. So there was no chance of any cross-examination. And during my evidence also, it remained unrebutted because as they did not appear, there was no people.
Whether the suit proceeded ex parte?
Suit did not proceed ex parte because they have only filed a WS. After that, they did not appear.
But did not cross-examine?
They did not cross-examine. So obviously there is no cross-examination and my evidence, entire evidence got unrebutted.
Okay.
So there is no contest even. When a document is admitted, that's why the Supreme Court has said, when a document is admitted without any objection, so there can be no later objection in regard to its admissibility. So that is one law point. So besides, there is no evidence to rebut the same. The defendants neither appeared, this is important, Your Lordship, neither appeared in the witness box to state their case on oath, nor it offered themselves to be cross-examined by the other side. And as such, a presumption would arise that the case set up by them is not correct. Mr. So-and-so, the learned counsel for the appellant in his argument and the case law, so-and-so versus so-and-so fully endorsed his view. Apparently, no inquiry is conducted by the defendant side about the claim of 97% of the work done by the plaintiff. The letter dated 13/11 rescinding the contract work bears no indication to that effect. There is nothing on record to show that the plaintiff has received the show cause letter in time. Now, in regard to this receiving of show cause notice, this show cause notice was first issued by the ONGC on 2/11/1995. That is Exhibit 6. Now, in the show cause notice, Your Lordship will find there is no indication as within how much time we have to file a reply. There is an indication saying that 7 days time is there, but from when this 7 days time has to be counted, from the received or when, nothing has been specified. Now, this show cause notice, they are saying that we have received, but we have replied, we have said that we have received on 11/11/1995. So on 10/11, we have already intimated them that we have already completed 97% of the work. And regarding this receipt of the AD card.
By Exhibit 2.
Exhibit 2. Exhibit 2 is the show cause notice.
No, by which document you in,
Oh, no. Exhibit 6 is the show cause notice.
your document is exhibit 2, 10,
Um,
11.
11. Exhibit 2. Yes, that is exhibit 2, yes. We have intimated that we have completed 97% work. Now, without ensuring that this AD card has been received by me or not, which I've said that I have received only on 11/11/95. So there is no chance provided to me. There's no opportunity to rebut the show cause notice. And this finding, which the learned trial court below has said that this AD card has to be produced by me. I am not the sender of the show cause notice. The AD card is always with the sender. Here in this case, that will be ONGC. So this appellate court so that this AD card is with them. So I'll read further. Then after repeated request, the plaintiff entered into agreement on 6/10/1995. Oh. No, not that. So finding at page 38. There is nothing on 1, 2, 3, 4, 5, 6, 7th line onwards. There is nothing on the record.
Yes.
To show that the plaintiff has received the show cause letter in time. The letter below observed in the judgment that the plaintiff could have called for the AD card to prove the that he received the show cause notice 11/11, or could have called for the postal document to prove the said fact, but he failed to prove the same. But the learned trial court failed to take in account that the AD card was in possession of the defendant. Here in this case, the ONGC, and the defendant side could not, if the defendant side could not have produced the same to rebut the claim of the plaintiff, but it has not produced the same. Mr. So-and-so in so-and-so case submitted that if a party in possession of the best evidence, which would throw light on the issue in controversy, fails to produce the same, then adverse inference can be drawn against such party. We have gone through the case law and so. Then next para, thus we find that the submission of Mr. So-and-so got sufficient force. There is no evidence on the record to rebut the version of the plaintiff that he has completed 97% of the work. Exhibit 2 and 3, the letter of the plaintiff. Exhibit 8, 11, 21 to 527 lends assurance to the claims so made by the plaintiff. Now these exhibits, which I have proved, Exhibit 8, 11, 21 to 527, there is no reference. The Lordship will not find any reference made by the trial court below. And furthermore, they have not objected to it. They have not appeared in the witness box. Therefore, adverse presumption should be drawn against them. The defendant failed to conduct any inquiry before rescinding the contract work, and the letter dated 13/11/1995 of the defendants bears no such indication. There is also no evidence to show that the plaintiff received the show cause letter in time. As such, he could not submit the reply. It also emerges that the contract work has been rescinded without hearing the plaintiff and giving him the opportunity of explaining the circumstances as to why he could not complete the work as admitted. He has done some of the work. Thus, mandate of clause so-and-so of the contract book standard form has not been complied with in its letter and spirit. And as such, it has been made arbitrarily in contravention of the said clause. Now this clause A, B, and C, this also states that before rescinding the contract, a notice has to be served on the contractor, and I have to give I have to give reply within 7 days of receipt of the notice. Now this fulfillment of this condition, this was not done by the ONGC. Now next para, this being the position, the finding of the learned court below on issue number 4 and 5 are erroneous, and the same requires interference from this court. Accordingly, we set aside the finding of the learned court below on these two issues. We find and hold that the order terminating the contract dated 13/17/11/1995 is illegal, void, inoperative, and malefied. And since we declared terminating the contract illegal, void, inoperative, inoperative and malefidy, we declared the work order dated 15/9/1995, an agreement dated so and so subsisting, and decides both the issue in affirmative in favor of the plaintiff. And accordingly, the appellate court reversed the finding passed by the trial court. Now, my senior has relied on one judgment in 2010 4 SCC 491, that mere marking of a document as exhibit, that does not amount to its proof. Herein, I have proved all the exhibits. I have not only marked them, I have given my evidence and proved those cases. It is for them to rebut that, since there is no rebuttal from the side of the defendant. So this judgment is helping me. I'd like to rely on para 23, 24, and 25. I'll read first. No doubt it is true that failure to prove the defense does not amount to an admission, nor it reverses or discharges the burden of proof of the plaintiff. But still, the duty cast on the defendant has to be discharged by adducing oral evidence, which the appellants have miserably failed to do. So exactly the same case here. Though they have controverted by saying that they've denied everything by saying that we have not completed 97% of the work by filing a WS, that has to be proved. There is no evidence from their side. Then 24, appellants, even though a defaulting party committed breach and failure to carry out a legislative imposition, then had still to convince this court as to what was the just cause for doing the same. Thus, looking to the matter from any angle, it is fully established that the appellants has miserably failed to prove and establish their defense. Now, 25, we are of the firm opinion that mere admission of a document in evidence does not amount to its proof. In other words, mere marking of exhibit on a document does not dispense with its proof, which is required to be done in accordance with law. So herein we have proved our case. It is for them to revert. We will miss the chance. And at this stage, at the second appellate court, whether it is permissible to argue the case on facts, that is another thing. Now, another judgment, which I'd like to refer.
Yes.
This passed by the Supreme Court in PC Purushottam Reddy versus S. Perumal.
It was relied on by the first appellate court.
Yes, yes. That it says that documents exhibited without objection is not open to be objected to its admissibility.
You mark the paragraph.
Yes, yes. 18 and 19 will be ready. Then another judgment, Vidyadhar versus Manik Rao. Herein the Supreme Court has said when a party does not enter the witness box, an adverse presumption is to be drawn against him. Paragraphs 15 and 16.
This was also relied on
Yes, yes.
by the first appellate court. Okay.
My senior in court number 10, I'd like to draw the attention of this honorable court. My learned colleague has stated that we have not examined the plaintiff, but we have cross-examined the plaintiff. His statement is wrong. We have already certified copy with us. We have cross-examined the plaintiff in 12/7/95 laws. PWD 1, the plaintiff we have cross-examined.
I don't have a copy of this.
No, this will be in the records. Now, whether you have put any questions on these exhibits which were relied on by the first appellate court.
Your Lordship, may I go to the?
in the house. Any specific questions on Dr.
Number of works under ONGC. I am a class 1 contractor. The present case is relating to so-and-so drill site. In the drill site, rig of so-and-so is set for
cross-examination.
for large oil and natural gas. If any rig remains idle, there then the ONGC issue loss of rupees lakh per day, some rupees lakh for the works at drill site. The work has to be done perfectly. I was one of the tenderers for executing the work, and I quoted the tender on 14,895. The tender was quoted for estimated cost of 5,80,540. It is not a fact that I quoted the tender rate of 231,180. Work was allotted to me with a view to execute within 7 weeks. It is a fact that I was asked to start the work within 7 days, but within 7 days the work was not done. I entered into an agreement for executing the work on 6/10/95. It is not a fact that I was served with a notice on 2/11/95, but I received, this is what I was saying, I have received a notice on 11/11/95. It is not a fact that I did not start the work within 7 days as per notice dated 2/11/95. It is a fact that though the defendant cancelled the work on 13/11/95 and forfeited any earnest money, it is not a fact that I issued 2 numbers of letters to defendant on 13/11 and 14/11, falsely stating that I completed 97% of the allotted work. It is a fact that the defendant issued me another letter on 20/11/95 stating that I claimed 97% of the work was completed without starting the work. It is a fact that I performed a civil rule. I preferred a civil rule before the Honorable Guwahati High Court, being 5215 of 95, for quashing the cancellation order. It is a fact that the civil rule was dismissed on 4/10/96. Therefore, I filed the present suit. It is not a fact that I am not entitled to get any claim and relief as per the prayer after dismissal of the civil rule. So there is.
Is there any specific question on Exhibit 8, Exhibit 11,
No, nothing.
Exhibit 21?
There is no mention of any exhibits even,
Okay.
apart from the show cause notice and everything.
Anything else? Heard Mr. J. N. Saiwala, London Senior Counsel. I am reserving the judgment. Learned Senior Counsel assisted by Mr. Das, Learned Counsel for the appellant. Also heard Mr. S. Datta, Learned Counsel for the respondent. Hearing concluded, judgment reserved.
Obliged. Item 16 to 18.
Yes.
In this case, Lordship, the accused arrested on 23/4/2025, Lordship, and 231 days. And this is a substituted case, Lordship. And no witnesses examined till today, Lordship.
Any accused has been granted bail.
No, Lordship.
Then
And 17th of December, Lordship, fixed for evidence in this month, Lordship. Last on 3 December was fixed, Lordship. No witnesses examined.
what is the offense?
Offense is Lordship case 8, Lordship. The affair.
103.
Yes, Lordship.
Why this case has come to this court? Earlier rejection.
My lord, earlier, my lord, one of the co-accused, my lord, named Mon Borua, my lord, whose, my lord, prayer of my lord bail was rejected by your lordship. And at that point of time, my lord, that is the today's item number 17, my lord. Both the matters came together, my lord. Osojit Borua, 17. And another one which is rejected, my lord, that was Mon Borua, my lord. It is a case of my lord Jorhat, my lord. That is a one Bihu function, my lord. The person was my lord.
Item number 17. In item number 17, rejection order is there.
No, my lord. In 17, not my lord. The earlier, my lord, along with that, another matter came, my lord. That is for Mon Borua, my lord. Another accused, my lord. Because I appeared in the matter, my lord, on that point of time, I remember. Here, my lord, that questions, my lord, remain at that point of time, my lord.
Putul. Bail application 2820. 2820 to 28/8/2025 or order to look. Yes.
My lord,
Let-
at that
let-
point, yes, my lord. My lord, actually, my lord, in the Bihu function, my lord. So, my lord, a boy was, my lord, brutally, my lord, beaten. Thereafter, my lord, he died, my lord. So, in this connection, my lord, one, my lord, that is the video footage from a mobile camera is there. Some, my lord, the eyewitness were there. On the basis of their statement, my lord, first position, my lord, one, my lord, the accused was arrested. And from his statements and taking the lead, my lord, others were arrested. Now, my lord, in this regard, my lord, TIP was also done, my lord. Now, my lord, that Mon Borua, whose prayer was rejected, he was, my lord, identified in the TIP. Same footing, my lord, item number 16, my lord, regarding, my lord, Babu Ali, my lord. He is also, my lord, that is item number 16, my lord, Babu Ali, before your lordship today, my lord. Babu Ali is also, my lord, in the same footing of the Mon Borua. He is also identified in the TIP, my lord.
Okay.
Now, my lord, the query was that regarding, my lord, item number 17, my lord, Osojit Borua, alias Osojit, and same thing is applicable, my lord, I think in the case of, my lord, item number 18, my lord, Jayed Haq, my lord, which is before your lordship today, my lord. Though, my lord, Jayed Haq is, my lord, come today. At that point of time, my lord, it was not came before your lordship. In this case, my lord, that is the, my lord, the co-accused statement was there, my lord. co-accused statement was there, but my lord, in the TIP, is both the accused persons were not identified, my lord.
17 and 18.
17 and 18, my lord.
Okay.
They were not identified. Then my lord was pleased to make a query, my lord, because in the search sheet, my lord, they stated one thing, my lord, in the search sheet, only my lord relevant part, my lord. I'm just reading it out, my lord. My lord, only my lord, that is relevant part, my lord. I'm just
Okay.
reading it out, my lord.
Cash pay.
I am, my lord, reading from my lord, item number 17, my lord. Osojit Burwas matter, my lord. This is page 37 from the search sheet, my lord. Page 37 of the petition, my lord. There is a para 7, my lord. During investigation, seized one USB flash drive, such and such model, such and such, containing video footage of the entire incident from Krishna Kumar, who was recorded the video of the incident through his mobile phone and also corrected the certificate so and so from Krishna Kumar. And now, my lord, may kindly peruse, my lord, para 10 of the search sheet, my lord, same page, my lord, para 10.
Yes.
During the investigation, the statement of the witnesses, video footage of the incident, post-mortem report, TIP, and statement of the accused person revealed that 24/2025 there was a Bihu function in such and such place, and the victim so and so had come to watch the Bihu function with his friends. At that Bihu function, some quarrel occurred between the accused person and the victim so and so. During the investigation, all the accused names were there. Now, at that point of time, my lord was pleased to make a query whether, apart from that is the co-accused statement, my lord, regarding is there entry or something else remains in the case diary, which suggests, my lord, that is, my lord, their presence was seen in the video footage. My lord, in this regard, my lord, on that point of time, my lord, as because the, my lord, that is the entry of the CD, though the statements are available, 180 statements are very much available, my lord, along with the Caesar list and all, but the entry of the CD was not available. So my lord was again pleased to call the, my lord, that is the entire CD, my lord. And on the basis of the direction of your lordship, my lord, on my lord 1911, my lord, another, my lord, that is state was, my lord, 10, my lord, that is also available. I have gone through that also, my lord. But the same way, my lord, that is the entry is not available. I have, my lord, gone through the statement of the, my lord, the person from whose, my lord, that is video was, my lord, seized, my lord. From his statement, it is not clear because he didn't identify the person. He only says that some people are there. The boy was lying. Some persons are taking, and at that later part, some people came and take him away. These parts are available, my lord. But my lord,
So what is the basis of
my lord, because, my lord, there is
co-accused statement?
co-accused statement is that, my lord, very clear, my
And
lord.
what
They are
is there in the video footage?
My lord, that part is not, my lord, because, my lord, the entry of the CD is not today also available with us, my lord.
CD is available.
CD is, my lord, not entire CD, my lord. That is the statement of the accused along with the Caesar list and all these parts are available. But the entry, the endorsement which made by the, my lord, police during the course of investigation, that's not available. In the new file also, my lord, 1911, there are 3 files even. First, my lord, some wrong documents were sent. Thereafter, my lord, on 2 occasions. So that is the position in case of, my lord, item number 17 and item number 18, my lord. And item number 16, my lord, it is, my lord, TIP, my lord, he is identified.
Who has identified?
My lord, he is identified, my lord, 2 persons, my lord. I have flag mark, my lord.
Who identified?
My lord, those who are, my lord, present at that point of time in the scene, my lord.
As witness?
Yes, witness him, my lord. Doing the, like in the similar, my lord, situation of Mon Borwa, which was rejected by your lordship. Mon Borwa was identified. This person is also identified. Others are also identified. Only these 2 persons, my lord, that is 17 and 18, they were not identified in the TIP, my lord.
So they were implicated on the basis of?
My lord, here the statements of the co-accused are there. As per the co-accused statement, they are implicated. my lord.
What they have stated.
They have stated, my lord, that they are also present and taking part in the, my lord, when, my lord, he was beaten, my lord, the disease was beaten, my lord. Those
Yes,
parts are there. my lord. And otherwise, my lord, it is, my lord, very, my lord, initial stage, not a single witness is examined, my lord. Because, my lord, last date, what my learned friend has stated on, my lord, 17, my lord. And one occasion, my lord, though two witnesses were present, they are not able to examine.
yes, what is your submission? On
Submission,
the same
Lordship.
ground, bail to one of the co-accused has already been rejected.
Yes.
Yes, Lordship, and item number 16 it is, Lordship.
Yes, how your case differs.
And Lordship, item number 18, Zaid Haq. And the eyewitnesses, 3 eyewitnesses there, Lordship. It is not disclosed the accused petitioner is Zaid is involved in this
Zaid,
case. Items 18.
Okay.
It is very clear, Lordship.
Item number
para-
16, what is your submission?
Submission is in the Lordship in the 231 days, Lordship, behind the
Okay.
bar, Lordship.
Heard. What is the status of the trial?
Evidence is
Evidence is, my lord.
Not a single.
Charges framed, my lord, not yet, my lord, my lord.
When is the next date?
17th of December.
17.
Who has identified the witness, name of the witness? Record to the auction.
Yes.
Heard, Mr.
Or-
What is your name?
Page Lordship, page 30, 30.
Yes, what is your name?
Lordship Zaid Haq. Para 8, Lordship.
You are also appearing for
Babu Ali,
Babu Ali.
Babu Ali and Lordship Zaid Haq.
Item number 16. Heard, Mr. A. Islam.
M.A. Mundal.
M.A. Mundal, learned counsel for the petitioner. Also heard Mr. K. Bashaw, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Babu Babu
Babu
Ali. Babu Ali.
Yes.
Jugal Kishore Dr. 1 witness, my lord. He
Babu Ali, who has been detained behind the bars since 23/4/2025 within bracket for last 231 days in connection with Jorhat PS case number 202/2025 under section 126 within bracket 2/118 within bracket 2/109 within bracket 1/3 within bracket 5 of BNS with added section under section 191 within bracket 2, 192, 1 within bracket 3, 190/103 within bracket 1 within bracket 2 of BNS. The gist of accusation, Code Para 3 from bail application number 2820/2020. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars for last 231 days. And though the charge sheet has been laid, however, not even a single witness has been examined till date by the prosecution side. He submits that the petitioner is ready to cooperate in the trial. However, considering the considering the long incarceration, he may be allowed to go on bail. On the other hand, Mr. K. Bushel, an additional public prosecutor, has opposed the grant of bail to the petitioner at this stage as the
Independent.
case in hand is of a serious nature where the victim was brutally assaulted to death, allegedly by the accused persons. He further submits that the present petitioner has also been identified as one of the perpetrator of the offense by one of the prime witness, prime within bracket independent witness during test identification period. Hence, he submits that unless the said witness is examined, it may not be proper to release the petitioner at this stage. As in such an eventuality, there may be likelihood of the present petitioner influencing the said witness. Hence, he prays for rejecting the application for bail. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the records of this case. The case in hand involves accusation regarding assault of victim boy by the petitioner, which led to his death. And there are sufficient incriminating materials against the present petitioner on record. He was also identified by one of the independent witness in test identification period. Hence, unless the said witness is examined, it may not be proper to release the present petitioner on bail at this stage when such grave accusation has been made against him. The prayer for bail is therefore rejected at this stage. He may, however, move an application for bail before the trial court after examination of the witness who had identified him during test identification period. This bail application is accordingly dismissed. Next, Dibu. Who else is?
Item 18. Not identified by the witnesses. Eyewitness.
My lord, in this, my lord, regard, my lord.
18 and 19.
My lord, 17 and 18.
17 has also not been identified.
Not identified, my lord. Earlier occasion also, my lord, that my lord, he was taken, my lord.
17 Duke. Date of arrest is same.
My lord, date of arrest is, my lord, 22/4/2025, my lord. In case of my lord, item number 17, and in case of item number 18, my lord.
Who is appearing for item number 17?
Yeah, my lord.
Heard Mr. K.R. Bora, item number 17. Heard Mr. K.R. Bora, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. This application, Baki Eke Rakhibo, name of the petitioner is Ashwajit Borwa, alias Ashwajit.
Regarding, my lord, that the query also made by your lordship regarding that is the video footage, my lord.
Yes.
That is whether, my lord, they are, my lord, during the course of investigation, my lord, after TIP, my lord, or my lord, when they were arrested, they were identified in the footage. That part, my lord, I am unable to, my lord, submit because, my lord, there is CD.
That is also relevant.
But
How will we find out?
Yes, my lord, because, my lord, in the CD, my lord, that endorsement, that is the, my lord, that is the notings, my lord, what they, my lord, entry, my lord, that is not available, my lord, in, my lord, 1911 also.
It should have been there
My
in
lord,
the,
that is not available. Only, my lord, the statements, Caesar list and others, my lord, documents, these are available, my lord, along with the.
how can we verify?
My lord. For that, my lord, I pray, my lord, only, my lord, those, my lord, very specifically, my lord, that is the case diary along with the entry, my lord, that should be, my lord, sent, my lord, my lord.
The entire case diary we can call again.
Or my lord, but my lord, that, my lord, submission may be recorded, my lord, those parts are not available, my lord, in the order, my lord. Because, my lord, that is not available, my lord. On 1911, they sent, my lord, from the learned trial court, my lord. It was sent, my lord. That is available, my lord, there. I have gone through that, my lord. That is
Whether
not
entire
just-
case diary is before us.
My lord, no, my lord, not entire case diary, my lord, because those endorsements are not available with us, my lord. Only the statements are available with us, my lord.
Facts, Sunidhibu. We are giving one more chance to
My lord.
Learned Counsel for the Learned Additional Public Prosecutor submits that though the present petitioner was not identified by any of the witnesses during test identification period, however, his involvement is on the basis of the statement of the co-accused as well as
The Sarsit, my lord, they stated, my lord,
video footage of the incident recorded by one of the independent witnesses. Learned Additional Public Prosecutor further submits that as to what were the contents of the video footage, there is no endorsement of the investigating officer in the case diary, as the case diary is not, as the entire scanned copy of the case diary is not available before this court. Hence, he prays for requisitioning the scanned copy of the entire case diary of Jorhat PS case number
20225.
202-2025. Considering the submissions made by Learned Counsel for the Learned Additional Public Prosecutor, let the scanned copy of the entire case diary of Jorhat PS case number 202/2025 be called for from the concerned trial court, the registry to take steps for requisitioning the scanned copy. Let this case be listed with 16th, no, December, 18th of December, 18th of December. And same order for Jayed Haq, 18 January, 18 December.
Deeply obliged.
Where is the appellant?
Lordship, perhaps they're not interested. Lordship may peruse the previous orders, Your Lordship, if of absence and then adjournments. It's the suit of the year 2001, Your Lordship, the decree is in my favor. Even no evidence was laid by the.
Who is the counsel?
The council was changed, Your Lordship, and then Mr. Chamua appeared for 2 days. His juniors. And adjournment was sought. Prior to that also, there were several non-representations.
What is to be done? We can dismiss it.
or default, at least, not on merit.
On merit, we cannot
It
decide it.
cannot be done.
Or should we give one chance? Next week. None has appeared for the appellant on call. Mr. B.J. Mukherjee, learned counsel for the respondent is present, who submits that on last occasion also, that is on 14/10/2025, when the matter was listed for hearing, the engaged counsel for the appellant sought for an adjournment, and the adjournment was granted for one last chance, for one last time, considering the whole pendency of the instant appeal. Stop. However, this court is inclined to give one more chance. This court is not inclined to dismiss this appeal for default today and grant one more chance to the appellant. Let this matter be listed in the first week of January on a date to be fixed by held that the High Court was wrong in dismissing the review without considering the
Yes, exactly.
without considering the new document which you have produced.
Only ground of, no, there is no due diligence.
No,
that was
no
the-
due diligence.
That was the ground.
Supreme Court further suggested that High Court may
True, no?
say,
It may not be amount to a specific direction that you have to send it, my lord, but question, my lord, ultimately your lordship can't decide here. If the document is genuine or not genuine, my lord, it has to be placed. Evidence has to be let. They will get the opportunity to cross-examine. And then, my lord, the court give his findings on that document and send it to before my lord. My lord will decide the review application. And my lord, the Supreme Court says that if your review application is ultimately disposed of, dismissed, then you can again approach the Supreme Court. If your lordship find the last part of the order.
My lord, may I submit, my lord?
In such view of the matter, we are inclined to set aside the impugned judgment, rejecting the review application to request to High Court to reconsider it on merit in accordance with law. Ordered accordingly, all issues on the law and factor of
review application has to be decided afresh.
Absolutely, my lord. Absolutely. That is the condition. Grateful.
Yes, Mr. Sahiwal.
My lord, may look into the last order, 30-10-25. Last order of this honorable court. On the other date, my lord, they pressed for an adjournment. My lord. The adjournment was granted. Now, my lord, we have some difficulty to argue this matter today. So what I would respectfully submit, my lord, that a date may be fixed, my lord. So the hearing may be done.
My lord, Thursday may be fixed, my lord.
My lord, after vacation.
I have no objection to accommodating them. Your lordship will definitely accommodate, my lord. Somebody in difficulty, my lord, let them accommodate. My lord, no matter, your lordship will kindly see, the order was passed by the apex court some a year back, 14 months back. Matter is pending since.
No, we have to hear the review petition. If
My senior friend, Mr. I is there, my lord. Next time.
Yes. My lord, your lordship rightly said that your lordship will hear the review petition first. And thereafter, my lord, if your lordship is convinced by our argument that this is a case which comes within the four corners of Order 47, Rule 1, then your lordship may pass necessary order after hearing us.
What is
So
your
I-
what is
My
your
lord-
submission regarding the observation made by the apex court in its judgment?
You know, the apex court has, I will only say that the apex court has dismissed the, set aside, my lord, the judgment by which the review petition was
The
dismissed,
observation made in the second paragraph.
my lord.
No, Mr. Agarwal, you are on the same side.
Yes, yes.
Okay.
Yes,
My lord, in fact, my lord,
because something has gone wrong with the online listing, my lord.
Mr. Sahiwala, you are
I'm
difficult.
the other side. Respond.
he's on the other side, my lord, since there is some difficulty
I
in your.
thought you are leading, Mr. Sahiwala.
No.
My lord, everything is left to the court. Nothing is decided. Nothing is decided. Only at one place has said that
Putul,
it was not correct in dismissing. That's the only thing your lordship will hear the review petition, and then of course other things will follow. We have made it very clear, my lord, if I'm permitted to say, we have made it very clear that we have given reason as to why the school admission register could not be produced. We examined the principal of Mihir Ram Saikia High School, and we had requested him to bring the.
no, we are not hearing it today.
More.
We are deciding on a agreeable date.
Of any date, I have no objection. Any date which your lordship thinks.
First week of January, my lord, if Daddy permits of the order. First week of January.
Well, since Mr. Ji will be lead, my lord, if he is convenient, my lord, there is no difficulty on my part.
6th of January.
I'll not be there.
Your lordship has fixed one of my case on the 6th. Will it be
Then-
convenient, my lord, to fix it on 8? 8
Eight.
is a hearing day.
Let it be on 8, my lord.
Okay.
I will have some difficulty to do
What, 9?
8,
8th.
8, yes.
8th
Yes.
is a hearing day.
Yes, my lord.
8 is a Thursday.
Heard Mr. D.K. Mishra, learned senior counsel assisted by Mr. B. Prashad, learned counsel for the review petitioner. Also heard Mr. A. Sahiwala, learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. Considering the submission, the prayer is allowed. Let this matter be listed on 8th of January as a fixed item
It is at the top of the list. my lord.
at 2 p.m.
Good.
as a fixed item at 2 p.m.
My lord.
I'm obliged.
All right.
Item 10.
Lordship, in this case, Lordship, the parties has went for mediation, Lordship, and in the mediation proceeding, Lordship, matter has been resolved between the parties. So our humble submission before the Honorable Court and humble prayer to the Honorable Court, that Lordship, that the matter may be disposed of by by narrating the conditions of the mediation and decree.
Where is the report of the mediation?
It is in the file, Lordship, it was flag mark, I suppose.
What was settled?
Lordship, the settlement is, the entire lane earlier was under our possession, Lordship, because we are the, representing the Namghar, a religious institution, Lordship. Now, the respondent herein has decided to, give a portion of the land by way of gift deed, and yes, some portion of land will be purchasing some portion, and the other will give the possession to the, respondent. This is the basic settlement between the parties.
I heard Mr. S. N. Krishnatre, learned counsel for the appellant. Also heard Mr. What is the name?
KD Sharma on behalf of PK Das.
A.D. Sharma, appearing on behalf of Mr. P.K. Das, learned counsel for the respondent. This matter was referred to mediation by this court on by its order dated 17/9/2025. And the report of the mediator has been received from the Guwahati High Court Mediation Center. Learned counsel for the petitioner, learned counsel for the appellant, as well as respondents have submitted that during the mediation process, the parties were able to settle their dispute amicably in terms agreed upon between them, on terms agreed upon between them, which has been reflected in the report of the mediator. report of the mediator. Who was the mediator?
Dr.
Dr. Nikita Barua. Dated 18/11/2025. As the parties have reached amicable settlement, this regular second appeal is disposed of in terms of the settlement arrived at between the parties and as reflected in the report of the mediator dated 18/11/2025. Let a decree be prepared accordingly. Let the report of the mediator be treated as the part of the decree. This regular second appeal is according.
So that the mediation report may be made a part of the order.
And
Accordingly,
let the report of the mediator be treated as part of this order.
But it can be reflected also in other matters. It was done if lordship pleases, that is up to the.
May be treated as a part of the order. And same may also be treated as a part of the decree to be prepared thereafter.
Declare prepared by the registrar.
Yes, registry to do the needful. This regular second appeal is accordingly disposed of on composition.
Deeply obliged.
11. Lordships, it is for hearing, but I have filed today in IA for production of new documents, Lordships, under Order 41 and Rule 27 CPC. Lordships. Because earlier,
Where is the
earlier disability certificate was issued only for 3 years, and subsequently in the year 2021,
I list one.
permanent certificate issued.
Let
So-
let the IA come, then we'll decide. Heard, Mr. What is the name?
SC Pandit.
SC Pandit, learned counsel for the appellant. Also heard Mr. A.J. Soikya, learned counsel for respondent number 1. Learned counsel for the appellant has submitted that the appellant has filed an interlocutory application under Order 41, Rule 27 of the Code of Civil Procedure 1908 for production of additional evidence at the appellate stage. For production of additional evidence within bracket and new documents at the appellate stage. However, the said interlocutory application is not yet placed along with not placed before this court. Registry is therefore directed to list the matter in
It will be given, Lordships. It is
next week.
next week.
Next week. And by placing the interlocutory application filed by the appellant along with this case record
Date, Lordship, 18.
next week.
Next.
Next week, and date to be fixed by registry.
Item 12.
Yes.
Appeal by the husband.
You are not audible.
Matrimonial appeal by the husband.
Okay.
I am from the wife.
Against
Against wife.
what is the issue?
This is an application. Very small matter.
Filed against the order of amendment. Amendment was allowed.
Amendment was allowed.
Allowed
You are against that.
against them.
Amendment is not fitting, amendment of the course title. Section of the.
It is all after cross examination. And my lord, there is.
That is why they're very small. I think after I will place this.
My lord, there is also one order from your lordship, my lord, allotting the case to the additional district judge, my lord. That is at page number 71.
Do not matter
Rohan Mehta. Your lordship was the district judge then.
whether I have passed any.
Yes, my lord.
That was administrative order.
Page number 71. my lord.
Do not do this. Allotment of
Yes.
court, allotment of court.
Case is transferred to the.
Lordship allotted the case to the. And that is not why. That is not why.
That in my view does not create a bar. No application of mine.
No objection.
Impugn order is Lordship 74.
So, my lord, what happened in this case, my lord, we have also cross-examined the petitioner. Prior to filing of the application of amendment.
Read the impugn order, please. Mr. Good.
Both parties are represented. Already heard both learned counsels. I intend to dispose of this Mizze case with the following peruse here. Petition 388 of 2022 giving rise to the Mizze case number so. It was filed by the plaintiff praying for amending the cause title of the petition 1904 of 19. In as much as to substitute section 27 of the Special Marriage Act with section 13 of the Hindu Marriage Act. Learned counsel for the defendant in his usual fairness would concede to the pair. It is now.
You have conceded before the trial court.
Oh, my lord, that is not a fact, my lord. Actually, there was no hearing on this point, my lord. Because earlier page number 73, my lord, will have a look, my lord. On the same day, it is order of the same day, my lord, non-represented.
But later on, both parties are represented.
No, my lord. That is, it is a page number, my lord, 73. Page number 73. Non-represented.
Okay, but order was passed on 22/7.
Same day, my lord. When, my lord, we did not get a chance to appear in this.
No, but order reflects that both parties are represented.
It is in page number 74 on the same day order, my lord.
Later on might be there might have been represented.
No, my lord, that was not there, my lord, because we are.
But we will go by the orders of the court.
Kindly take the page 72. It will be clear.
So, first of all, my lord.
Matter already be heard. That day was only for the.
What is your objection?
Our limited prayer is that we have already filed an application on 4/6/2022. That is for calling for the marriage certificate from the concerned marriage officer, my lord. Under section 30 and order 16 rule 6 of the CPC, my lord. We have filed an application for calling for the marriage certificate. So that was not disposed of. Thereafter, they filed an application for amendment. After before that, we have completed cross-examination of the petitioner also. In our WS also, we have pleaded that we have not entered into any special marriage. But despite that, they have adduced evidence saying that there was a special marriage. So, my lord, in her cross-examination, she also admitted that she was earlier divorced. earlier married, not divorced, my lord. So whether divorce has been obtained by her. So after cross-examination, they came up with the idea that cost title of the application is required to be sent. Because we have filed the application prior to that for calling for a marriage certificate. Because well, if there is any marriage of the petitioner with any party, special marriage, then my lord, there must be a divorce before that. That's why we filed an application on 4/6/2022. my lord. That is the page number, my lord, 66. Oh, 66 is their application, my lord.
No, what is your main objection against the,
Well, we may be hard because, my lord, we have already disclosed everything in our.
hard on the order,
Whether amendment should be allowed because, my lord,
but your annexure 17N shows that you have been already heard. Order dated 21/7/2022.
my lord, 21/7, we are not even present in the court. That's why, my lord, LCR was called for, my lord. We are not even present on that.
You want to say that the court passed wrong orders.
Yeah, maybe some misunderstanding, my lord, we don't want to blame the court, but thing is that we want to be heard only this much.
What is it? What is your contention before the main objection? Order 6, Rule 17.
Order 6, Rule 17, my lord, they have filed an application. on
The suit remains divorce suit.
Divorce suit, my lord, they have filed an application on the Hindu Marriage Act. So we have cross-examined the petitioner record.
Under Hindu Marriage Act.
Yes.
Then they are right in praying for substitution of Section 27 with Section 13 of the Hindu Marriage Act. If their petition is under Hindu Marriage Act.
Only thing, my lord, kindly come to page number 64, my lord.
Sixty?
Oh.
Yes.
Yeah, seen the petition number 302 of 22. Under order 16. Read section 30 of the CPC, praying for providing marriage certificate from the office of the marriage officer. So, my lord, without disposing of this application, my lord, amendment was allowed, my lord. If there was, because it's a old matter, if there, we have only prayed for calling for a marriage certificate.
How it is linked with the amendment which was prayed for?
Well, my lord, if there is a
Amendment was allowed because of the ground of wrong quoting of the section, as well as on your concession. You conceded before the trial court.
my lord, actually what happens, my lord, that's why, my lord, trial court record was called for. We were not present on 21.
Trial court record is called for.
It is very clear.
Yes, what else is your submission? We will dispose it after.
Yes. Our price is that, my lord. We have cross-examined the PW. First, my lord.
Yes.
Then, my lord, this application we have filed for calling for the marriage certificate. If there is no marriage certificate, then it's fine, my lord. if there is a marriage certificate, my lord, then the case is to be decided whether it should go under section 27 or Hindu Marriage Act.
No, but suppose your prayer is allowed and marriage certificate is called for
Called.
and marriage certificate arrives. Suppose it comes, how it will affect? It may strengthen your case.
Yes.
How will it will affect the,
My lord, then only thing is that whether she has made the correct statement before that court or false statement, because on oath she has stated that she entered into special marriage with the petitioner. On oath she has stated. So credibility of the witness will be affected.
yes, anything else? Yes,
In
you,
fact, Lordship, if we go through the record, then we'll see that on 21st, 27, 22, that order itself says they already heard both sides. Means the matter was heard on 16th.
no, suppose it was heard. Their submission is that in your plaint, you have made statement that marriage was
Yes,
registered marriage.
That I'm coming. I will show you, Lordship, in their WS, they have filed the WS, the WS in para 6 of the WS, they admitted that the social marriage. If it is so, our statement was that after the marriage we have already we also make it registered, but that would not affect the whole case. If the registration is come, then if you Lordship in page 28, page 28.
Oh, first you married socially, then you
Yes.
registered. Okay, okay.
There. And that is in para 6, Lordship will find in para 6 of page 28.
Para 6 of page.
Page 27, Lordship will find as regard the made in paragraph 2 of the petition, the petitioner, the respondent in this regard, Yassan Beg to state that he admits that his marriage with the petitioner was solemnized on such date according to social right and rituals.
Okay.
But they denied the statement that after marriage, they went to the marriage officer. Only that point. My contention is that even what they are now saying, it is not in the ground, but it is an amendment of a cost title. The order 6 rule 17 in what they said in the after evidence, that mischief will not role play in this case. It Lordship know, even in the code under section 153, they can correct this cost title. And Lordship, when I'm searching about that, I have got a very I've got a judgment.
So this is not amendment of the pleadings.
And similar facts,
Okay.
and similar what they're submitting, this similar one, but it is maybe from Kerala division bench. But Lordship is considered is a persuasive precedent. Here, Lordship will find they are same, exactly same, if you go to the para 4, the petitioner seeking a decree for dissolution or marriage caption here, section is a Mohammedan law, again about. Involving provision of 7th, petitioner is correct to the portion of heading section 27 of the Marriage Act. Here, we want to insert the 13 of the Marriage Act. The similar, sir, paragraph 9, the court's finding. That is my submission.
No, my lord. Their application, my lord, they paid for
for this
dissolution of
reason-
marriage under section 13 in place of section 27. my lord. In their evidence in affidavit, they have stated.
Otherwise, they are not seeking any amendment of pleading.
Yes.
Content.
Other parts, they are not seeking any amendment, my lord.
Okay.
My lord, thing is that, my lord, supposingly her marriage, special marriage was performed with, because in her cross-examination, your lordship would see, she admitted that she was earlier married, which she has not pleaded in her application, divorce application. She has not pleaded that she was earlier married. But during cross-examination, it came out that she was earlier married, my lord. So supposedly there is a marriage certificate of the petitioner, of the divorce petitioner, my lord, with some other person, my lord. If it is not disposed of, it is not dissolved, then, my lord, case would be different. That's why we filed for a application.
Heard Mr. UK Burman, London Council for the petitioner. Also heard Mr. PP Borwa, London Council for the respondent. I'll pass orders in chamber. I'm dismissing the civil revision petition. Reasons will be mentioned in the chamber.
Development.
Government will file one affidavit, lordship. So we will maybe fix that vacation, lordship. Can you please fix the date one?
What is your name?
R.A. Locker.
Heard Mr. R.A. Locker, Learned Counsel for the appellant. Also heard Mr.
And Colita.
N. Kolita, Learned Government Advocate,
Yes.
appearing for the state respondent. Mr. Gogoi, you are also appearing.
Respondent number 13.
Mr. L. Gogoi, appearing for respondent number 13. Learned Government Advocates submits that you will be filing an objection in the IA.
Yes, lordship.
The state respondent intends to file an written objection in the interlocutory application, and for that some time is sought for. Considering the submission, the prayer is allowed. The prayer is allowed. Let this matter be listed after second week of January on a date to be fixed. No, on a date to be fixed by registry.
That's a bit.
Item 12, commerce. Item 12, we'll keep it as part heard. Because we don't have much time.
May I please give our points in